Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous the insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Hello, and welcome to today's drive time edition of Attorney Melanie Little, bringing it to you live on Monday, February 10th of 2025, with more shenanigans, more tomfoolery, and more ballyhoo. You know it. This is the re-persecution of Karen Read, and we are here for it. We're going to be very, very busy till the alleged new trial date of April Fool's Day. I don't know if that's going to happen on April Fool's Day or not. But as I said, and as we've predicted, there was another motion today, another dropping, this time by the defense. And the defense wants the metadata. They want the metadata, and they want a forensically sound copy, including metadata and logs from the Canton PD surveillance system. Apparently, they tried to work it out after last week's conference, and Hank Brennan said, no, make a motion. And so we have the motion. We have the dropping today. So we're going to take a look at that. Today is also the day that Michael Proctor was to appear in front of a Massachusetts State Police trial board for day 2 of his trial or hearing administrative proceeding to determine whether or not he will be terminated. Seems that a decision will not be forthcoming on that until perhaps June, but we do have a little clip to look at from NBC 10 Boston that aired this morning. We also have all parts of the Karen Read interview that she did with Ted Daniel of Boston 25 that aired last night. Part of it aired last night after the Super Bowl, for those of you who were able to stay awake for it. I believe that the Glare did, I don't know if he did both portions on his show last night, but there was a 6-minute portion that aired last night after the Super Bowl, and there was a 6-minute portion that aired this morning on the 7 a.m. show. So we've got that. Also in court today, in federal court, was Matthew Farwell, who is accused of murdering Sandra Birchmore and is currently sitting in Club Fed, which is what we call federal prison, or somewhere. He's in holding somewhere in Massachusetts. You may recall that Sandra Birchmore's death was initially ruled a suicide. That was also investigated by Canton PD initially, ruled a suicide, and then it took the feds' involvement to come in and find 35,000 text messages between Sandra Birchmore and Matthew Farwell, the Stoughton police officer who started grooming her when she was just a teenager and took her virginity at age 15. She then became pregnant with married Matthew Farwell's baby when she was 23 years old, and then tragically was murdered by Matthew Farwell, allegedly, in, I think it was early February 2021. right? It's 1 year before the murder of Boston police officer John O'Keefe. And Matthew Farwell has been sitting there for a while, cooling his heels. He's waived his right to a speedy trial. And there was another adjournment granted today. So maybe we'll do this in sort of like a chronological type order. And I think while we give some people a chance to get in here, we'll take a look at the Farwell order that resulted from today's appearance, because, we cover all things. And this is becoming a very Massachusetts-based channel because of the huge viewership that we have from Massachusetts. And you are all outraged, and we are outraged along with you. I from New York, and many of us worldwide. If you're not from Massachusetts, or even if you are, tell us in the chat where you're watching from. I saw some pre-chat chatter asking me to move this up because those of you across the pond can't stay awake until 11 p.m. And apologies, but this has to be on my schedule as well. So my schedule, this is where it fit into my schedule today. And I know a lot of you were watching Lawyer and it just coincidentally worked out. I think he covered Karen Reed's interview, or maybe one small portion of it. It just coincidentally worked out that he ended right before I came on. So for those of you coming, or who are coming over from Peter's channel, Lawyer welcome. Welcome. This has become a worldwide story, and the entire world is watching. Let's take a look at what happened today on Matthew Farwell's case in federal court. This is an order resulting from today's proceeding. It's an order on excludable delay in the United States of America versus Matthew Farwell. And reads as follows. Defendant had an interim status conference today, February 10th, 2025. Discovery is ongoing. Let me just make that a little bigger so I can read it. The government is presently considering requests for discovery made by the defendant last week. The parties are working cooperatively to wrap up discovery in the case. The case is continued for a further interim status conference to April 15th, 2025 at 10 a.m. I'll put that in the calendar. Federal court is never televised, nor is it open to the public on Zoom, as far as I'm aware. But we can report on it. We can look at documents. I have access to the system, so we can get the documents and we can follow along. With the assent of the parties, it is hereby ordered that pursuant to the provisions of 18 U.S.C. Section 3161 H7A, interest of justice, the case will be continued and time will be excluded under the Speedy Trial Act so that the defendant may continue preparing for the disposition of the case. The clerk of this court shall enter excludable time for the period from February 10th, 2025 up to and including April 15th of 2025. Footnote 1, which indicates the parties are hereby advised that under the provisions of Rule 2B, 2B of the rules for United States magistrates in the U.S. District Court for the District of Massachusetts, any party may move for reconsideration by a district judge of the determination and orders set forth herein within 14 days after receipt of a copy of this order, unless a different time is prescribed by this court or the district judge. The party seeking reconsideration shall file with the clerk of this court and serve upon all parties a written notice of the motion, which shall specifically designate the order or part thereof to be reconsidered and the basis for the objection thereto. The district judge, upon timely motion, shall reconsider the magistrate judge's order and set aside any portion thereof found to be clearly erroneous in fact or contrary to law. The parties are further advised that the United States Court of Appeal for this circuit has indicated that failure to comply with this rule shall preclude further appellate review, citing some federal cases, and this is signed by U.S. Magistrate Judge M. Page Kelly. Okay, so it looks like they're basically stopping the clock from February 10th until April 15th, which is a little more than, well, maybe around 60 days, because February is only like 28 days this year, right? 27. I don't know. I don't think it's a leap year. So again, I don't know if he waived his speedy trial. I may be thinking of another case, but they're going to exclude that time from his speedy trial rights. And he will be back in court on April 15th. Many people feel that there's a lot of speculation that Matthew Farwell may be rolling over on some other people. I don't know. I have no information. Cannot confirm or deny, but another adjournment to April 15th. A lot of people would like to see Matthew Farwell pay for what he did to Sandra Birchmore. I am one of them. I have an entire playlist on the Sandra Birchmore case. If you are not familiar with it, please familiarize yourself with it. Many people think that the feds were investigating the Sandra Birchmore case, and that's how they became involved with the Karen Reed case. I don't have any information to confirm that either, but, word on the street and stuff. Doesn't look so good for old Matthew. No, Anthony, sure doesn't. Anthony's here from Ohio, and he can see it all the way from Ohio. He can see the shenanigans, the tomfoolery, and the ballyhoo. Tazo, thanks for being with me for 5 months. Says, love Mondays with Melanie. Just another manic Monday. We thinking song lyrics here. Moon Goddess, thank you so much for gifting 5 memberships. And also a special thank you to you for going to the Penny McGee trial and being boots on the ground in the courtroom for Penny McGee when Penny McGee was in Judge Cononi's courtroom being tried for manslaughter for having a verbal argument. Maybe she shoved him, maybe she didn't. There's conflicting testimony. And then her ex-husband died of a heart attack, and she was standing trial for manslaughter, facing 20 years in prison in front of Judge Canoni. It was a bench trial. Nobody was in the courtroom. It was empty. And we were talking about it when nobody else was. And Moon Goddess went, and she went to court. Thank you for doing that. And also thank you so much for gifting 5 memberships. And for those of you who were randomly selected by YouTube to be cupcakes, welcome. GB, how does men? Oh, that's a very nice compliment. Thank you so much. Thank you. Thank you. It's a good ring light is what it is. People think I use filters. There are no filters. It's StreamYard. They don't have a filter. I have a ring light, a good camera, a side lighting over here. It's all about good lighting, ladies. All about good lightings. Good lightings. Thank you, GB, for your compliment. Twilight Zone 913, Stoughton, Mass. You went to school with Matthew Farwell. Wow, Twilight Zone 913. Was he a creeper in high school? I mean, because allegedly, he was grooming young girls when he was a Stoughton police officer. Him and his, yes, that's okay. I know what you meant. Stoughton. He and his twin brother, both, Matthew and his twin brother, had relations with Sandra Birchmore. Not sure if his twin had relations with her when she was a minor. And Robert Devine, who was also Stoughton PD, right? He also had relations with Sandra. Again, not sure if she was a minor at the time, but they met Sandra Birchmore through her enrollment in the Police Explorers program when she was just a kid, maybe 11 or 12. And she really wanted to be a police officer and really sort of revered police officers. And what a tragic, tragic ending to her story. Thank you, Pierre, for hanging 14 months. You are an OG. You absolutely are. Because I think we've only had memberships, I think, for 14 months. So thank you, Pierre, for thanking me and for always being here and being a very valuable member of the community. Twilight Zone says, Twilight Zone went to school with Matthew Farwell in Stoughton. Says him and his brother were weird. Well, that's your opinion, but I would have to say, that story breaks my heart. Breaks my heart. And you know what? Trooper Garino was the one who downloaded Matthew Farwell's phone during the investigation of the Sandra Birchmore, quote, suicide. And Trooper Nick Garino couldn't find or missed or selectively excluded 35 or 32,000 or 34,000 messages on Matthew Farwell's phone between he and Sandra Birchmore. And you know what's so crazy about that is that they seized Sandra Birchmore's laptop from her apartment on the day that they found her body, and she had a laptop that was a Mac, and she had an iPhone. So all those messages were on Sandra Birchmore's laptop, and they had them. Why did they ignore them? Yeah, that's not for me to tell you. That's for you to think about. And I wonder if Matthew Farwell is going to take a deal. He's going to make a deal. If he's going to throw some other people under the bus, or if that's ever going to go to trial. It's going to be interesting, but we're here for it. Yep. Nick, quote, "Kill me now, Garino." Spoken TC. Yep. Oh, Charo, thank you. Says, "I'm the best law tuber watching from Europe. Great selection of cases that you cover." Thank you. Thank you very much. Thank you for watching from Europe. You guys are everywhere. You guys are everywhere. All right. Okay, uncivil. This is something that I am completely staying away from, not getting involved in this. Don't know what it's about, but I'm not going to address it on my show. And I would ask everyone in the chat to please do not discuss any outside drama on my show, because I'm Switzerland. I'm Switzerland, and I love the fact that I have no idea what's going on out there, because I am single thread on this. I just don't care, and I have way too much other stuff going on in my life to care. And if you guys want to go talk about that stuff, there's other places to do that. It's not going to be in my house. Okay. Love you. Love you all. All right. Let's take a look at what Boston 10 reported this morning regarding Michael Proctor, because that's interesting. Let's take a look. Here we go.
Well, 6:02 right now in the spotlight of the Massachusetts State Police, once again shining on one of its former employees, Trooper Michael Proctor. Proctor was the lead state police investigator on the Karen Reed case, now facing allegations of misconduct.
Yeah, no longer on the police force. NBC 10's Alicia Palumbo joins us live this morning from State Police Headquarters in Framingham. Alicia, those allegations set to be reviewed again today.
Look at Alicia Palumbo. First of all, she's out there at 6 a.m. in Framingham. It's bitter going there. And she's like on the spot reporting. Good on her.
Yeah, this is a continuation of a hearing that began last month over misconduct allegations involving Trooper Michael Proctor. Now, it obviously has implications far beyond Proctor's own career in law enforcement. With Karen Reed's retrial coming up in just a couple of months, any discipline levied against Proctor would be used by the defense against him. As the lead investigator in John O'Keefe's murder case, Proctor faced allegations of misconduct as well as criticism for his highly offensive text messages about Reed that were read aloud in court during the first trial. Proctor was suspended without pay after a mistrial was declared in Reed's first trial last July. NBC 10 Boston legal analyst Michael Coyne says Proctor's conduct could hurt the Commonwealth's case during the retrial in April.
In my opinion, it couldn't look much worse right now.
Okay, love this guy. Love this guy. His name is Michael Coyne. I just want to move these Coyne. I want to move the captions and give him the respect that he deserves, because like the Commonwealth could not look much worse than they already do. I don't know how to make these captions smaller, so it is what it is. But here we go.
During the retrial in April.
In my opinion, it couldn't look much worse right now. Though the language that he used, the things he was telling his friends, and the involvement of his superiors in some of those text messages, to me, it's virtually catastrophic for the government as is. So it only could marginally get worse as I see it, but it could get worse. Obviously, if he's terminated and now you still nonetheless have to put him on the stand.
Now, following the conclusion of this hearing, any disciplinary recommendations would be sent to the state police colonel and the state's post commission. We're live at State Police Headquarters in Framingham. Alicia Palumbo, NBC 10 Boston.
Yeah, so there's that. And I agree. That I would be also extremely surprised if any decision was announced on Proctor before Karen's trial ends. But, how long can they hold that for? Because although the trial is supposed to start on April 1st, we don't know if it's going to. We haven't seen any decision from the appellate court yet. Nothing from the SJC. How long can they hold off? I don't know. I don't know if they have to render a decision within a certain number of days. I'm not familiar with the administrative rules on that proceeding, but That's interesting. Alan Jackson is representing Karen Reed in the retrial. Yes, yes, he is. Med gas guy, he is. He absolutely is. Robin's like, I love that you're Switzerland. I need you to be Switzerland. Thank you for being Switzerland. Also, something else I noticed going on in the chat. I try not to let the chat distract me from what I'm doing, but sometimes it's unavoidable. I do not allow viewers, chatters to bash other creators on my channel, in my chat, in my comment. I just don't. I don't allow it. I have had the unfortunate situation where I go on another creator's show and people bash me in the comments, and the comments are allowed to sit there and the chat is allowed to, and I don't think it's cool. I don't think it's classy, and I'm just not going to allow it. Okay. So please guide your actions accordingly. Chat responsibly, comment responsibly. It's just, there's ain't no time to hate, barely time to wait. Oh ho, what I want to know. How does the song go? All right, we don't have time for it. Not here, not on my watch. Not on my watch, cupcakes. All right. Moving on. Let us now move on to the motion. The motion. Mike Dorado is here. Mike Dorado is here. Hey, Melon Cupcakes. I'm watching from beautiful Philadelphia, home of the Super Bowl champions, Eagles. Love you all, and thanks for all you do, Mel. Thanks, Mike. Were you here yesterday for the halftime show? I did a halftime show because I needed some comic relief. So we watched some of Trooper Proctor's testimony, and I just said I had no interest in the halftime show. I was not in any way dissing Kendrick Lamar. Quite frankly, I don't even know who Kendrick Lamar is. And that is also not a diss. It's not a diss to rap. It's not a diss to the art form. I just wanted to come on and entertain you guys. And I know that I think you were here. And also there's a bit of congratulations to the Eagles. I was rooting for the Eagles too. Bit of hubbub chatter today about the trophy presentation. There was some missteps, I think, during the trophy presentation. I didn't get a chance to dig deep into that, but I think people are not happy about that. Do you guys do a parade in Philadelphia? Are you, because, you know, like in New York, we do the ticker tape parade. And I think in Boston, you guys do like duck boat parades. So what do they do in Philadelphia? That's amazing. And congratulations. So that's amazing. Donna, thank you for hanging around for 13 months. And she loves my opinions. So there's that. Qbert. Hi, Qbert. I was so good at that game, Qbert. Every time you come in, I say, I was a really good Qbert player. I'm just saying, back in the 80s, that was like a video game, for those of you who don't know. An actual video game where you had to put money in, stand up, and actually play Qbert. And I was really good at Qbert. Thanks to 5. Divine grew up in Canton and is the same age group as the Canton crew. Well, that's interesting. Good citizen. I wish the news would also include Proctor's involvement with Sandra. Well, that's interesting. Do you think that Proctor had any involvement with Sandra Birchmore? Good citizen and Qbert, I think, are local to the area. So I don't know. I don't know what you guys know, but we'll see. We don't like too much rumor and speculation. If you like gossip, rumor, and innuendo, though, I suggest that you go subscribe to Kathy's channel. The name of her channel is Gossip, Rumor, and Innuendo, and we love her here. And every morning, she releases the video that's like 10 or 15 minutes long, and she talks about true crime, but she's hilarious. And she doesn't, she's like, you don't come to me for the details. You come to me for the tea. And she is so funny. I know there's so many of you. Also, he was the lead on Sandra Birchmore. Proctor was. I don't know about that. I don't think that he was. But we did go through all of the Proctor was involved. He was. We did go through all the Canton PD reports and the MSP reports. So it was a long time ago, you guys. It was a long time ago. It was Fanning and Garino on Birchmore. Yeah. Muggs 0426 says Rob Devine graduated in 1990 from high school, along with Mike Lank. Also grew up with Chris Albert. There's so many incestual ties in this case, in Canton, in surrounding towns, that it's like everyone's related. Everyone's related. It's like Kevin and Bacon land. It's like less than 6 degrees of separation. It was Walsh that Proctor was involved in. Yes, Team Brittany. Yes. No, we're covering a lot of cases. A lot. Fanning was the lead investigator on Birchmore. Thank you, Kelly. I knew I wasn't going crazy. But it's okay, you guys. We get confused. There's a lot of cases in this town. There's a lot of corrupt cops, maybe, in this town. We don't bash all cops because, there are good priests and bad priests. There are good cops and bad cops. There are good lawyers and bad lawyers, good doctors and bad doctors. And sometimes doctors allegedly kill people, like Dr. Ingolf Turk, who allegedly murdered his wife, Katie McLean. And I heard from another one of Katie McLean's childhood friends today who sent me some messages. So remember that Dr. Turk, whose case is also in Norfolk County Superior Court, who had been assigned to Judge Cannoni, has been reassigned to a different judge. We went over, Dr. Turk has made a motion to change venue. His the parade is Friday. His trial is supposed to start on March 25th. We need to catch up on that because there was a Commonwealth response to the motion to change venue. And we will also be covering the Turk trial. They wanted a change of venue, not because the Karen Reed trial was going to be going on at the same time, but for other reasons. I have a playlist also on the Turk case, Tuerk, if you're interested. RIP Katie McLean. From what I hear, I've heard from a lot of her friends, and she was a very, very lovely woman who died way too soon. They also asked in the Turk case for a bigger buffer zone in the event that it did happen at the same time as the Karen Reed trial, because they don't want their jurors influenced by the supporters and protesters outside the courthouse on the Karen Reed trial. All of this remains to be seen, but we do know that the parade for the Eagles is on Friday. So there's that. Hit the like button, please. That would be so lovely of you. So lovely. There is something in the water in Norfolk County market. There, no doubt about it. No doubt about it. Thank you, Hubert. Proctor is not involved, and Sandra's right. He's involved, though, in Brian Walsh. Yes, Brian Walsh, his attorney, is Larry Tipton, who also represented Penny McGee. If you haven't watched the Penny McGee trial, you should also watch the Penny McGee trial. Okay, so there's that. All right, let's look at the motion that was filed today. It is fire by the defense team. They're coming out. Guns a-blazing. Not having any of it. I already got my red pen out before the show started because you know how much I love a red pen. Call me Alice. As you can see, Alice in Wonderland is above me because I fall into the rabbit hole and I don't get out. What was that? I've fallen and I can't get up. What was that old commercial? Fallen and I can't get up. Yeah, gloves are off. Gloves are off. Free Billy Tibbets. All that good stuff. Brickhouse is fanning us skeletons in his closet. I'd be looking at him closely, and Sandra Birchmore. A lot of people have said that, Brickhouse. A lot of people have surmised that Fanning is far more involved in many of these things than we know. That remains to be seen. Dove's House, thank you for the 10, says, do you think that during the next trial, Jackson should cross every witness that discusses unauthenticated evidence by saying, so you're asking me to trust me, bro? Or trust you, bro? Why should I trust you, bro? Yeah, good. Well done. Well done to you, Dove's House. I'm here for it. This is filed this morning. This is docket number 483. Defending Karen Reed's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody. God save the Commonwealth. Now comes the defending Karen Reed and respectfully moves this honorable court pursuant to Brady v. Maryland and Massachusetts Rule of Criminal Procedure 14 to compel the Commonwealth to produce the video surveillance footage from the Canton PD between January 29th of 2022 at 12 a.m. and January 29th of 2022 at 11:59 p.m. and all metadata and logs associated therewith in a forensically sound manner so that this evidence can be turned over to the defense. Now, I'm going to break for a second to just say this should go without saying. It should go without saying. This is what they're supposed to turn over. In fact, this is what Judge Daniel O'Malley said from the bench during Karen Reed's arraignment, February 2nd, 2022, from Stoughton District Court from the bench. And David Yannetti said, Your Honor, I filed a motion for preservation of all evidence. And the judge said, well, I mean, that kind of goes without saying, but yeah, I'm going to grant it. And it's rare that we need to see motions like this in criminal cases, but here we are, Sarah and Shock and Horror, who is not only an amazing moderator for me, but also an amazing and generous contributor to this channel. 7 months flew by. So glad to be a cupcake. I'm so glad to have you. The reason that we're called cupcakes is because I have this sign over here somewhere behind me. I'm a mother of 5. And I've had this sign for a very long time. It is my daily mantra. You can't make everyone happy. You are not a cupcake. Just not a cupcake. Right. On January 22nd, 2025, the Commonwealth disclosed for the first time that additional video surveillance footage taken from the Canton Police Department may be in the possession of law enforcement on a retired detective's work computer. What? What? I'm sorry, what? Unless the data at issue is properly forensically imaged and preserved, the corresponding logs relating to the video surveillance footage, which should contain the identity of the individuals who accessed the surveillance system, the date of the download, and underlying metadata associated with the actual files, will be destroyed. If they're not already, I added that last part. The Commonwealth has indicated that it is objecting to properly forensically imaging the computer and/or department's video file system such that the defense can obtain a forensically sound copy of the requested information. The metadata underlying the video files at issue is not only central to this case, but is also exculpatory, and if properly imaged, will potentially reveal significant exculpatory, relevant, and material information about the underlying data, namely dates of creation and information pertaining to whether any of these files were altered in any way, period. It is absolutely necessary that this information be obtained in a forensically sound manner. I think I said matter. It's manner. Sound, forensically sound manner. Now is a good time to remind everyone to hit the like button because it helps the algorithm, pushes the video out, and helps other people find us. Unless the Commonwealth images the device at issue and obtains this critical evidence in a forensically sound way, the Commonwealth will deny Ms. Reed access to exculpatory information, which underpins some of the most highly contested and important evidence in this case. The Commonwealth's proposed process will destroy critical evidence, namely relevant and exculpatory metadata underlying these video files, in violation of Ms. Reed's constitutional right to effective assistance of counsel and to due process under the law is guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 5th, 6th, and 14th Amendments to the United States Constitution. Article 12 of the Declaration of Rights of the Massachusetts Constitution, the U.S. Constitution, Amendment 5, and all of these other citations to which each and every American citizen should be entitled to. And therefore, please, you need to, not even please, like this is a given. You need to give it to us. Ain't no other way about it. This is the way it's supposed to be. This is the way you're supposed to turn evidence over. Yes, Colin, thank you. With today's image manipulation software, metadata is vital. Yes. That's right. Spinky says, duck around with the evidence. But I'll allow it. I'll give it to him. Hank Spellcheck. Scott, you keep changing your name and you confuse me. You confuse me a lot, but I figured out that it was you because, you're hilarious. Hank's Spellcheck. He has renamed himself SPEL check. Thank you. Thank you, Scott. Yeah. Okay. Mudrucker says, how do I know it's exculpatory? If it proved her guilt, We'd have seen it on TV every day since the day Officer John O'Keefe died. That's right. That's right. And then they go on to quote Commonwealth versus Mitchell. Defendants have an unquestioned right under the Sixth Amendment and Article 12 of the Massachusetts Declaration of Rights to obtain relevant evidence that bears on the question of his guilt or innocence, which otherwise helps his defense. And Rule 14 is intended to ensure the realization of that right. In addition to her constitutional rights, Ms. Reed also has a statutory right to obtain evidence in advance of trial and prepare her defense. Massachusetts Rules of Criminal Procedure clearly state that the Commonwealth must provide, must. This is not optional, my friends, must. This is a must. Oh, should I get my red pen back? Okay, hold on. Let's even make it thicker this time. Must provide certain mandatory discovery of evidence within the possession, custody, or control of the Commonwealth to the defense in order to meet its discovery burden. And that is citing Massachusetts Rule of Criminal Procedure 14A1A. Information subject to such mandatory discovery includes all material and relevant police reports, photographs, tangible objects, and that is bolded and underlined there. All intended exhibits, reports of physical examination of any person or of scientific tests or experiments, and statements of persons the party intended to call as witnesses, as well as any facts of an exculpatory nature, that is also bolded and underlined. The rules also indicate that the defendant may move for discovery of other material and relevant evidence not required by subdivision A1. Ms. Reed respectfully requests that this court order the Commonwealth to provide the requested discovery to which Ms. Reed is entitled under Rule 14, the Massachusetts Declaration of Rights, and the U.S. Constitution. Factual background. Yes, fire on acid. Fire on acid. Doesn't this make the retired officer a witness? Yes, yes, oh yes, it does. And we have found out, I think, through another motion that it is an officer named DGM Pietro. I don't know anything about him, but yes, it does. Thank you, Charlie Lynn, for gifting a membership. Thank you to Irish Wolfhound. Irish Wolfhound Mama for also gifting a membership. You guys are awesome. Factual background. Ms. Reed is accused of the following crimes arising out of the death of Officer John O'Keefe. Murder in the second degree, in violation of Massachusetts General Law 265. That is count 1. Manslaughter while under the influence of alcohol. That is count 2. And leaving the scene of personal injury and death. And that is count 3. On October 5th of 2023, this court ordered the Commonwealth to produce all video evidence obtained in connection with this case, along with all associated metadata. That too is bold, italicized, and underlined. So it seems we did talk about an order to preserve. That was an order that was granted on February 2nd of 2022. And then this court, meaning Judge Cannoni, ordered on October 5th of 2023, this was a subsequent order, ordered the Commonwealth to produce all video evidence obtained in connection with this case, along with all associated metadata. And what we're seeing now is these little trickles, these little snippets of video, all of a sudden magically revealing themselves and now being turned over to the defense when they were ordered to be turned over as late as October 5th of 2023, as early as February 2nd of 2022, they were ordered to be preserved, which was well within the 30-day period that they are now telling us the exact QVision system used at Canton PD overwrites its own video. Shenanigans, tomfoolery, or ballyhoo. Take your pick. See Exhibit 1. We don't have Exhibit 1 attached to this. In spite of this standing court order, the Commonwealth recently notified the defense that additional video surveillance footage from the Canton PD recorded on January 29th, 2022, and the metadata associated with that footage may be in the constructive possession of the Norfolk County District Attorney's Office through its agents at the Canton PD. Okay. I just want to point out to you, Canton PD was conflicted off of this case on the morning of January 29th of 2022, when it was discovered, although it shouldn't have had to have been discovered because everyone knew that homeowner Brian Albert, who was the owner of 34 Fairview, whose lawn Officer John O'Keefe's body was found on, Brian Albert was a Boston police officer. John O'Keefe was also a Boston police officer. And Brian Albert's brother, Kevin Albert, was a police officer with Canton PD. Hence, there was a clear conflict. And after Canton PD cleared the scene around, I think it was a little before 8 a.m., they were conflicted off the case. Although some witness, I think it was Yuri Buchanan, testified at trial that he thought they were only conflicted off the case for interviews, and it was cool if they used their conference room and their Sally port and all that stuff. Well, go figure. Now we find out that this surveillance video is still in the possession of a retired Canton police officer. Orwellian, yeah. A little bit. The Commonwealth's proposed protocol for obtaining this information will destroy relevant metadata associated with this critical evidence in violation of a court order. A. Procedural history relating to Canton PD video surveillance footage. A brief summary of the procedural history relating to the video surveillance footage at issue is set forth herein. The Commonwealth has provided the defense with Canton PD footage on 3 occasions, and that goes to footnote number 1. Notably, I'm going to read the footnote now. Notably, when Mr. Erickson arrived at the Canton PD to extract video from the DVR system, the security camera system was set to overwrite older video surveillance footage with new video surveillance footage after approximately 30 days. Notably, however, each of the 3 instances in which the Commonwealth produced Canton PD footage to the defense was far outside the 30-day window, after which the Canton PD DVR system was set to overwrite older video recordings. Thus, an agent of the Commonwealth must have saved all of the aforementioned footage in playable format at some point before the end of the 30-day period, which ended in February of 2022. The Commonwealth therefore had care, custody, or control of all the footage produced to date during the discovery phase of the initial trial and chose not to turn it over to defense in a timely manner. I underlined and chose twice because that's how important that sentence is. Thank you, Scott McGinnis, for your 10. Canton PD, although it said they were conflicted out of the case, would have lost the case anyways the minute it became, a homicide, no matter what. So that is confusing to me. Massachusetts State Police takes over there. Yes, they do take over if it's a homicide, but they still, may work with local PD, right? To just use their facilities, perhaps. But in this case, they shouldn't have done any of that because of the clear conflict. So yeah, I agree. And thank you for the 10. I appreciate you so much. Charlie Lynn, thanks for the 5. Hank, I want to turn over all evidence, deserved or not. Also, Hank, I object to turning over forensically appropriate evidence. Yes. Yes, Charlie Lynn. Yes, you're right. Pierre, thank you for your 5. What if the officer who saved the Sallyport video did so to protect himself if all this backfired? Well, that's a good question. That's a good question. What if? What if any? Thank you, Pierre, for your 5. Dove's House, thanks for the 5. You don't want metadata. Who needs metadata? We create our own evidence. You can't be any more metadata than that. Trust us, bro. Commonwealth. Thank you, Dove's House. J. Michael RN says, is there a public record retention law in Massachusetts? How would it be allowed to let the DVR overwrite? Well, there's a way to put portions of that footage on that system on a legal hold. That's what they should have done. They didn't do it. There's going to be a lot of issues with regard to that. Great question. Let's keep reading. Thank you, J. Michael, for your super chat. Loner Gypsy, thanks for becoming a new member. Appreciate you. On April 4th of 2024, shortly before the first trial in this matter, the Commonwealth produced footage from the Canton PD main driveway, Canton PD Sallyport front wall for the very first time. Feels like the first time. Feels like the very first time. Name that tune. The Sallyport front wall footage provided by the Commonwealth omitted a 42-minute interval during which the SUV arrived at the Canton PD Sallyport garage. Trial transcript, volume 28, at page 31, line 9 to page 31, line 22. This missing footage could have been used to show the condition of the SUV's right taillight upon arrival at the Sallyport, and to date would be the only footage that serves this purpose. Yep. Thank you, True Crime Addict. That is Foreigner, I believe. Yes, feels like the first time. Feels like the first time. I'm behind on the chat. And Tell the Truth's head is going to explode. Oh, thank you, Debbie Blair, for coming in with some hot new news. NBC 10 Boston just posted Proctor will have at least one more day of hearings. Well, that's interesting. Boy, they couldn't even decide it in 2 full days of hearing. Now they need another day. Take a look. A lie unchecked becomes the truth. Yes, Kimmy. Yes. Yes. Yes, it does. The condition of the right rear tail light of the Lexus SUV at the time it entered law enforcement custody is perhaps one of the most critical and highly contested issues in this case. Mid-trial, on April 23rd of 2024, via a share link entitled, quote, additional Sallyport video download link, end quote, the Commonwealth produced additional footage from the Canton PD Sallyport back wall. At trial, Trooper Yuri Buchanan testified on direct examination that the footage of Ms. Reed's vehicle from this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV, and that, as seen in the video, no law enforcement officer approached the right rear taillight. That's right. That's right. That's what he testified to. He did. On cross-examination, however, it became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality, despite neither the Commonwealth nor Trooper Buchanan having mentioned it on direct examination. You remember that because we were screaming about it. Therefore, when the video appeared to show a person standing near the left rear taillight of the vehicle, in actuality, that person was in fact standing near the right rear taillight, i.e. the taillight at issue. Yes, Clerk Jim Clown, Yuri was just like, trust me, bro. Oh, is Rich Schiffer here? Hi, Rich Schiffer. We have duck emojis. We have duck emojis. Because that was a ducking ridiculous sham of a prosecution as well. You know. Rubber ducky gate. It remains unclear why this inverted video was withheld by the Commonwealth and produced to the defense in the middle of trial after the initial Canton PD surveillance footage was turned over by the Commonwealth. Wow. Is it unclear though? Is it? I can see clearly now the rain is gone. Most recently, post-trial. Yep. Post-trial on October 10th of 2024. The Commonwealth again provided new video surveillance footage, this time from the Canton PD church side exterior, first floor corridor, rear lot main side, and rear lot cruiser side angles. In case you're counting, that is 4 different cameras, 4 different camera angles, which must mean at least 4 different, brand new, never before seen, magically revealed themselves videos turned over after the ducking trial was over on October 10th, 2024, after Hank Brennan became involved in this sham of a persecution, after probably, perhaps, maybe he said in open court, I'm going to turn over everything, Your Honor, everything, whether it's exculpatory or not, whether I need to or not, whether it's required of me or not, I'm going to turn it all over. Karen Reed case is the hot potato case of Norfolk County. Hot potato case. Nobody else inside the office of the Norfolk County District Attorney's Office, and I don't know how many lawyers they have there, but it's quite a lot. None of them would touch this case. So the hot potato was passed to outside counsel Hank Brennan, who was hired for $75,000 at the rate of $250 an hour. He's a defense attorney. Obviously had to stop practicing and focus on this case for $75,000 at $250 an hour. Why? Why would he do it? Why? It was a hot potato. There was no conflict within the Norfolk County DA's office, but nobody would touch it. So what happened? Did Hank Brennan come across this video and say, holy duckin', for the love of the traveling Mary, nobody ever turn this over. I better turn this over, because if I don't, and it is found out that this exists and it's exculpatory, I could be disbarred. Back to the document. This footage shows Brian Higgins arrive in the parking lot of the Canton Police Department at 1:26 a.m., enter the Canton Police Department, and is seen speaking on the phone to some identified individuals on the phone as he is leaving the Canton Police Department at 1:34 a.m. Significantly, this material and relevant evidence, which establishes Brian Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left the Canton PD shortly after O'Keefe's death, was withheld from the defense at the first trial. Can I have some shock and horror? You should be outraged. The video surveillance footage at issue was a major point of contention at trial, in no small part because the Commonwealth was utterly unable to establish any chain of custody for the various clips of video produced to the defense from the Canton PD. The footage produced by the Commonwealth is rife with issues that call into question its accuracy and forensic viability, including the presence of the inverted video and the large-scale gap missing from the feed at the precise time at which Miss Reed's Lexus should have been shown entering the Canton PD Sallyport garage, in spite of the fact that the Commonwealth claims that the video surveillance feed is motion activated. The fact that the Canton Police Department produced video surveillance with an inverted video and a gap in the footage at the critical moment, i.e. at the precise time Ms. Reed's SUV arrived at the Canton PD garage, is not trivial. It goes to the heart of Ms. Reed's defense. In preparation for trial, the defense requested access to the Canton PD DVR system and drives that hold recordings from the Canton PD security camera system so that the defense expert, Mr. Erickson, could obtain video files in their native file format with all available metadata from January 29th, 2022, between 12 a.m. and 11:59 p.m., along with any associated log files. Nina is outraged. I'm just trying to find where I left off. Hold on. The way Canton PD technicians extracted the video data from their DVR system is insufficient for forensic purposes and has resulted in the permanent loss of the original surveillance video data. The CPD DVR system, like most, stores videos in a proprietary format. CPD uses the DVR interface to pick and choose which videos to save, and then that data is converted by the system into a playable format. The resulting file is almost always of lesser quality than the original, and because it exists in a different format, the resulting file will not hash verify to the original. As such, forensic experts cannot properly test the authenticity and integrity of the video footage. In response to the defense's request, Special Assistant District Attorney Hank Brennan agreed to allow defense access to this critical information and to make the arrangements necessary for Mr. Erickson to extract video from the DVR system. Accordingly, Mr. Erickson traveled from Phoenix, Arizona to Boston, Massachusetts on December 11th, 2024, and after making the arranged visit to the Canton PD, returned to Phoenix on December 12th, 2024. However, when he arrived, all relevant footage and corresponding logs had been erased from the DVR system. I'm going to break from the document for a moment to remind you that we just went over an entire motion for costs based on expert Erickson's futile trip from Phoenix to Canton PD, because when he got there, they were like, huh, what are you doing here? We don't have nothing. We got nothing. We don't know nothing about nothing. We got nothing for you. And so Karen's team sought costs of over $12,000 that it cost this expert, that it cost the defense team or Karen Reed herself on a futile expert mission. Judge Cannoni denied that motion. And her reasoning for said denial was that she thought Mr. Brennan told Mr. Jackson, yeah, we don't even know if it's going to be there. And that Mr. Jackson said, yeah, you're right. We don't know if it's going to be there either. And that was her basis for denying the motion. It's important to point out that the amazing supporters of Karen Reed in one day raised enough money in the defense fund to cover that $12,000. So thank you to all of you for contributing to Karen Reed's defense fund, because we've learned she's currently over $5 million in debt and continuing for the attorney fees for this wrongful persecution. She has sold her home. She has liquidated her 401k. They wanted her to take a plea, but she didn't. And this is still going on. Yes, well done. Okay. B, facts relating to attempts to meet and confer. After Ms. Reed expended a significant resources to send an expert to the Canton PD to image the DVR system, on January 22nd, 2025, Defense Counsel received a call from Special District Attorney Hank Brennan indicating that he recently obtained information. Okay, stop what you're doing. Listen up. I'm going to start that sentence again. On January 22nd, 2025, Defense Counsel received a call from Special District Attorney Hank Brennan indicating that he recently obtained information that a retired Canton PD officer had downloaded the surveillance footage at issue on his work computer and cloud-based account. He informed Defense Counsel that he was going to have his own expert download the surveillance footage, but would permit our expert to fly back to Canton to be present for the imaging. That's right. That's right. We heard them talk about that last week during the hearing on February 6th. At the hearing on February 6th of 2025, the court invited both parties to meet and confer informally on the issue of the video download in order to obviate the need for further court intervention. The defense did this in good faith. On February 6th of 2025, Defense Counsel met and conferred with the Commonwealth regarding obtaining the requested video surveillance footage and associated information from what has been varyingly referred to by the Commonwealth in separate discussions as a, quote, retired defective. I mean, that was a Freudian slip. Retired detective's work computer and, quote, the Canton Police Department's detective file. Following that meeting, so this must have been after the court hearing on February 6th, they met and conferred, and that's what attorneys are supposed to do. Before you waste the court's time making a motion, meet and confer. Talk about it. See if you guys can work it out amongst yourselves. Work it out, talk amongst yourselves, work it out amongst yourselves. Don't bother the court unless you have to. Following that meeting, Attorney McLaughlin sent an email stating that, quote, the Commonwealth will attempt to download any videos to the extent that they exist. See that? See that? To the extent they exist, which are related to your client's vehicle at the Canton PD and presently stored on the department's video file system. But I thought there was nothing on the video file system. The Commonwealth will video the process and produce documentation of the retrieval process and any responsive videos. And that's Exhibit 2. It must be a copy of her email. Attorney Little, that is not me, Attorney Little. That is not me. This is Elizabeth Little, no relation, just a coincidence, very common name. Attorney Little responded requesting that, quote, the Commonwealth expert conduct a full forensic image of the computer and or video file system at issue, such that our expert can obtain a copy of all available metadata relating to any of the videos at issue, including any log files associated with the videos and or deleted data that may be recovered from the computer. There's been a lot of deleted data in this case, a lot of deleted Google searches, text messages, screenshots, a lot of log files that don't exist, no chain of custody logs, no evidence logs, no logs of who was on scene when the taillight pieces magically appeared when the CERT team got there, no logs. It is shocking that they have to ask for it, and yet here we are. Special District Attorney Hank Brennan then responded, indicating that the Commonwealth would not be obtaining a forensic copy of the information at issue. When Attorney Little requested that the Commonwealth ensure all metadata associated with the related files and any associated logs are copied onto a thumb drive, Attorney Brennan objected and indicated the defense would need to file a motion with the court. Really? Really? We're not going to give you the metadata and the logs on a thumb drive? No, we object. We object to metadata and log files. Is he objecting to giving it to them at all? Or is he objecting to putting it onto a thumb drive? It's not really clear. But he objected and said, no, make a motion. On February 6th of 2025, Attorney Little responded stating, and that is why she was not in court. A lot of people were like, why isn't she in court? Why isn't she in court? You know why? Because she's boots on the ground in her LA office, sitting at the computer, getting ready to draft this stuff, fire off emails. She's amazing. I believe she was made partner at the firm during the course of the first trial or right before the first trial at some point. Boy, did she earn it. On February 6th of 2025, Attorney Little responded stating, if the Commonwealth is objecting to properly forensically imaging the computer and/or department's video file system such that we can obtain the information we've been requesting, namely all video footage from the Canton Police Department on January 29th of 2022 from 12 a.m. until January 29th, 2022 at 11:59 p.m., and all metadata and logs associated therewith, then I will file a motion with the court tomorrow. This information needs to be obtained in a forensically sound way. That is all we are asking to have happen. As of the filing of this motion, the defense has received no response from the Commonwealth. Crickets. You know what? We need a cricket emoji. We don't have a cricket emoji, but it's just been crickets from the Commonwealth. They filed this motion and, crickets. Yes, Lindsay, she's incredible. She's incredible. You know what? Grace Bazar says our girl Eliza is so eloquent. She's not snarky. She could have been. She wasn't. The defense does not want to expend additional resources to send an expert to obtain this information. Rather, it is simply requesting that the Commonwealth, which has retained not one, but two digital forensics experts, forensically image the device in question to ensure that the data is obtained in a forensically sound way. And look, this is not a huge ask. This is obvious. This is obvious. I think the first time that anybody, probably in the general public, even heard about metadata was during the Johnny Depp and Amber Heard trial, right? There was a lot of talk about metadata during that trial. It wasn't quite in the public vernacular till maybe that trial. I don't know. But here we are, 2025. We're still talking about metadata, and they don't want to give it to them. That was before my time on LawTube, that trial. Absent this court's intervention, the Commonwealth will be permitted to destroy critical metadata underpinning one of the most seminal pieces of physical evidence in this case in violation of Brady and Massachusetts Criminal Rule 14. As such, the defense seeks immediate relief from this court. They're like, Your Honor, before they do anything, stop them from destroying all this stuff. We need an emergency motion hearing. Because you know what, crickets? Because we asked them, we told them if they don't provide us with what we're asking, which is a very simple ask, we're going to have to make a motion. Crickets, here we are. Argument. Pursuant to Brady, which mandates that the prosecution turn over all exculpatory evidence in Massachusetts Rule 14, the Commonwealth must comply with the aforementioned request to produce and preserve the Canton Police Department's video surveillance footage from January 29th, 2022. Going on to cite some cases, although this is obvious, there are the citations for you. And it's a little bit repetitive, so I may not read this whole entire argument. In addition to her constitutional rights, Ms. Reed also has a statutory right to obtain evidence in advance of trial and prepare her defense. Massachusetts Rules of Criminal Procedure clearly state that the Commonwealth must provide certain mandatory discovery of evidence within the possession, custody, or control of the Commonwealth to the defense in order to meet its discovery burden. Information subject to such mandatory discovery includes all material and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any person or scientific tests or experiments, and statements of persons the party intends to call as a witness, as well as any facts of an exculpatory nature. The rules also indicate that the defendant may move for discovery of other material and relevant evidence not required by subdivision A1. All right, let's just take a minute to point out here that before the first trial, Adam Lally filed what they call a certificate of compliance, which is a sworn to statement that is filed with the court that says, Your Honor, we have turned over everything. We've turned it all over. We've turned it all over. But alas, in the middle of that trial in April, they turned over more. I'm going to assume for purposes of this it's not even a hypothetical, this is real. I'm going to assume Adam Lally did not have this Canton PD footage in his possession, because I'm going to assume that despite what you may think about Adam Lally, he would not risk his bar license for this case. And that if he had this, he probably would have turned it over. Let's just say he would have turned it over. Which leads us to only one other conclusion. Canton PD had it and didn't turn it over. MSP had it and didn't turn it over. Until they needed to. Until maybe the trial wasn't going the way they thought. Maybe now all of a sudden they needed this inverted video to show that, hey, look, nothing to see here. Look the other way. Look. Yeah, you can see a bunch of officers surrounding that rear tail light, but it's not the right rear tail light. It's the left rear tail light. But alas, it wasn't. It actually was the right rear tail light because that video was inverted. And then we find out that, but wait, there's more. There's more video that they just turned over in October of 2024. And then we just noted that a couple of days ago, they turned over more video of the Lexus being backed into the Sally Port. If whoever's trying to ask questions, like it's hard. I can't read the chat when I'm reading to you because I have to focus on the screen and what I'm reading. So I don't know. Christy says, I didn't have a question. I made a statement. He said it in Microdots videos and 2 other YouTube videos. I don't know what we're talking about here, but hi, Gen X chick. Impressed to ya. Thanks for becoming a new member. Dr. Russell is the GOAT. Thanks for tuning in from Norway. Careful with the duck. We'll be charged with littering. I think those littering charges were dismissed. Glamasuz, Proctor's next hearing, 313 and 314 if needed. Goes up the chain and no timeline for decision. It's just another Manic Monday. Oh yes it is. So 313, 314. So this is Farwell. Now I have all these new things to put in my calendar. Proctor. They're not done with him yet. Hearings. Thank you, Glamasuz, for coming in with the info. Saving me time going to look for it. Is there a protocol for withholding evidence? I think that's facetious. Shouldn't be. But here we are. Thank you for your super chat. All right. Furthermore, as articulated in Com v. Ruddock, courts have recognized the importance of preserving metadata associated with any digital evidence, explaining that the forensic examination of the computer data by an expert retained by the defense is an essential component of effective assistance of counsel. In this case, is self-evident. As noted by the court in Boyd, forensic examination may provide valuable evidence as to how images in question made their way onto the laptop and when, how often, and by whom they were accessed. Whether the images were actually disseminated or stored in a manner consistent with an intent to disseminate them is a critical issue in this case. Indeed, absent consultation with an expert, defense counsel will be severely handicapped in his cross-examination of the Commonwealth's experts. And that is a direct quote from another case. But it certainly does apply to this case as well, almost exactly on point. Kay Willis is here. She's a realtor. She's gifted 5 memberships. Welcome to the 5 new members. And thank you, Kay Willis, who's here for all of your real estate needs. Tell the chat where you practice real estate, where you sell real estate, just in case anybody's looking for a house or an apartment or a townhouse or something as such like that. Thank you, Kay Willis, realtor. You're the best. Always gifting, all the time. Here, the requested video surveillance footage and accompanying metadata constitutes tangible evidence that is clearly relevant, material, exculpatory, and necessary to Ms. Reed's ability to defend herself at trial. Oh, there she is, Kay Willis. Kay Willis is in Massachusetts, south of Boston. All of your Massachusetts real estate needs, look up Kay Willis. Awesome. Women helping women. That's another thing we do here. Might be unpopular, but that's what we do. Moreover, on October 5th of 2023, this court ordered the Commonwealth to produce all video evidence obtained in connection with this case, along with all associated metadata. See Exhibit 1. The defense is simply asking for this court to order the Commonwealth to obtain and log this evidence in a forensically sound manner so that no additional exculpatory information is destroyed. What the duck? It's like, doesn't the defense have a right to know whether this stuff has been tampered with? Where's the metadata? Where's the metadata? Where's the log? Where are the hash values? It's as if the rules of evidence don't exist in Norfolk County. It's as if the hash values don't mean anything. And I think Brennan calls them hashtags. And Alessi was fire when he got up and said that. I don't know what hashtags are. It's hash values. 60 seconds or less. And he did it in 60 seconds or less. Love Bobby Alessi. We're just going to call him Bobby from now on. Bobby Alessi. Love him. He's come into the case he's a New York attorney from a white shoe firm who has come into this case. He's working for free. For free. That is how outraged so many attorneys are about this debacle that is going on, and it will go on again for a second re-persecution in Norfolk County, that there are white shoe lawyers out there from big firms from other states that will come in and work for free for justice. Got to tell you something. Here, the requested video surveillance footage and accompanying, I think I read that already. The defense is simply asking this court to order the Commonwealth to obtain and log this evidence in a forensically sound manner so that no additional exculpatory information is destroyed. Conclusion: for the above reasons, Ms. Reed respectfully requests that this honorable court grant her motion to compel discovery XOXO. Ellen Jackson, Elizabeth Little, Worksman Jackson and Quinn, Los Angeles, David Yannetti, also known as Misty Yannetti, Ian Henchy, Bobby Alessi from DLA Piper, New York, New York, dated February 7th, 2025. Today's February 10th. This was actually filed on Friday, but it didn't hit the docket till today. And that is when Elizabeth Little emailed this motion over to Hank Brennan on Friday. Happy weekend, Mr. Brennan. Happy weekend. Also attached to this motion, as required, was an affidavit signed by, this would be docket number 484. Let me get that for you because we like receipts. I like to do things by the book. Docket number 484 is right here. Affidavit of Alan Jackson in support of the motion to compel discovery of forensically sound copy of January 29, 2022 video surveillance footage in law enforcement custody. I, Alan Jackson, do hereby depose and state that the following is true to the best of my knowledge and belief. I am a partner at the firm Worksman, Jackson and Quinn LLP. I represent Karen Reed, pro hoc vice. I submit this affidavit in support of the defendant Karen Reed's motion to compel a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody. The facts set forth in this motion are true and correct to the best of my knowledge. I believe that my client is constitutionally and statutorily entitled to discovery of the information as set forth in this motion. I believe it is in the interest of justice for this motion to be allowed. Signed under the pains and penalties of perjury this 7th day of February, 2025. XOXO, Alan Jackson. Because that's the way we do it in Massachusetts, Mr. Jackson. That's the way we do it. We're going to move on in a moment to Karen Reed's interview with Ted Daniel that we know now was done on January 29th, 2025, because they said so during the interview. But before we do that, Deborah wants to know, is the prosecution allowed to introduce new evidence in the second trial? Well, depends on whether it magically reveals itself. You mean the new evidence that they've just turned over? Well, there will be motions in limine about that, I'm sure. So that remains to be seen. But like the judge says, she's the gatekeeper. This is a whole new trial, so remains to be seen. Depends on if it was just discovered. A lot of factors at play there, but nothing surprises me anymore in this case. Nothing does. Nothing surprises me. And the Goodwins are here, as always. Our favorite couple, our favorite YouTube viewers, couple, YouTube viewer couple, has gifted 5 memberships. So thank you to the Goodwins. Love you both with all of my heart, all of my heart. Queen Olive says the Commonwealth is screwed up so much. I'm shocked that this scam is going forward. Well, join the club, sis. Join the club. It's insane, right? No, I do not have Exhibit 1. I don't have Exhibit 1. Does anybody have Exhibit 1? The exhibits were not attached in the court docket, so the documents that I have do not have that with it. So I don't have it. Sorry. Prosecution wants every minute of footage from her recent interviews. We went over that motion on Monday because right away, Hank Brennan can do things too sweet when he wants to, because as soon as the promos went up for these interviews of Karen Reed, or this interview with Ted Daniel, by the way, his name is Ted Daniel. Ted Daniel, it is singular. Everyone is out there calling him Ted Daniels, and it's like nails on a chalkboard for me. But his name is Ted Daniel. He's with Boston 25, which I believe is the Fox affiliate in Boston. He got a lot of flack for wearing a pink shirt one day to court. He wore a pink shirt to court, and the trolls were attacking him like, "Oh, you're so biased. You must be free Karen Reed because you actually had a pink button down on." I don't know. A lot of men look real good in pink, and a lot of men are confident enough in their masculinity that they don't mind wearing a pink shirt. I don't know. Was he trying to send a signal? A hidden message? Was there a hidden message in there? I don't know. But Hank Brennan can do things very, very quickly when he wants to, because quite quickly he made a motion, and we covered that on Friday or Saturday or when, I don't remember what day. He wanted all of the outtakes from these interviews that had not even aired yet. They aired last night after the Super Bowl, and some of them, and the second portion aired this morning. So we have 2 6-minute pieces to watch. Thank you, Inside Down Twilight Zone, for your super sticker. I appreciate you very much. All right, let's go back to last night's first 6-minute clip. Hang on. First 6-minute clip. Okay, and this is the one that was released. This is one that they showed last night after the Super Bowl, after some other game show aired on Boston 25. The first 6-minute clip. Okay? Hi, Greg. Thanks for the 5. Thank you for making me laugh, because sometimes if we don't laugh, we're just going to cry. Just joined in. So pardon me if already asked, but the defense filed a new motion for the judge to order the prosecution to just follow the rules. Yeah. They just want the metadata, because apparently they just don't want to give it to him. Hank said no, make a motion. So that's what they're doing. Yeah, I know you're not wrong. You're not crazy. You're being gaslit. Dove's House, did Jackson drop the ball for not asking for this authenticated direct source data during the first trial? It's okay to be unmerciful. It was turned over in the middle of the first trial. So it never should have been admitted into evidence, in my opinion, to begin with. So there wasn't an opportunity to do that during the first trial. And then it ended in a mistrial. So it did not become an appellate issue. Had she been convicted, it would have. We don't know what they discussed at sidebar. All those sidebars are being currently transcribed. I think maybe they're done. They're going to be in the motions in lemonade that we're going to see. We've renamed them motions in lemonade because the closed captions called them that one day during the first trial. So there's that. I don't think that there was time. Now's the time, because all of this new video keeps revealing itself. Just keeps revealing itself. Thank you, Glamasus. There are 3 6-minute clips, 2 last night and 1 this morning. Okay, well, I've got 1 6-minute clip. I'll look for the other one. Thank you for telling me that. I'm not sure if 2 of them are the same. I don't know. I'm looking on Boston 25's YouTube. Thank you, the Goodmans, for gifting another membership. You're awesome. All right, let's wait. So are you saying that this one from 17 hours ago is not the first one? Hold on. Hold on. Well, this is the one first. This is the one we're watching first. Don't cry about it. This is what I have pulled up. Somebody told me that Glera said last night during his show, this is really easy what we do. This is really easy. I'm here to tell you that it's not that easy. He was drinking wine. He may have misspoken, but there's a lot of prep, at least for me. There's a lot of prep that goes into these shows, a lot of prep that goes into what I'm going to talk about. It may not seem like it. I may make it look like it's totally seamless, but there's a lot of prep that goes into this. And I just wanted to clear up that misconception. All right, here we go. This is released 17 hours ago or something like that. And this is Ted Daniels exclusive with Karen Reed. We're going to stop. We're going to talk about it. Feel free to talk amongst yourselves in the chat while we do this. And here we go.
We spent several hours with Karen Reed over 2 days with and without her attorneys. We asked for the interview and were somewhat surprised she said yes. Reed tells me she withdrew to New Hampshire for 2 months after her first trial. She's been preparing for round 2 ever since.
I have nothing to hide.
Okay. So all Ted Daniel had to do was ask for it. He asked for it. She did not approach them. She didn't say, hey, you want to interview me? He approached her and said, hey, Karen, would you do an interview? Maybe he approached Alan Jackson. Would you do an interview? And it was a 2-day interview. And she's not afraid to speak out. So many people have been saying, if I was innocent, I'd be screaming from the rooftops. Why is she not screaming from the rooftops? Why is she has spoken out on the courthouse steps. She has spoken out during several interviews, Nightline, Dateline, 2020, Vanity Fair, among others that you guys will point out to me. And she's saying, I have nothing to hide. I'm willing to do this interview with you. And they've already moved for the cutting room floor footage. They're trying to catch her slipping up. Exactly. This is the 8th time, my 8th time watching it. This is Boston 71, but I'm here. Everyone's going to have a different opinion on this. Ted is the best reporter in Boston. Ted Daniels is a nice guy, according to Patty. Some comments have said she should take the stance and she talks to the media. It's like, no, it's not the same. No, it's not. She is allowed to talk to the media. There's nothing wrong with that. There's nothing improper about it. However, she cannot be forced to testify in a trial because, Fifth Amendment and stuff like that and stuff. All right, here we go.
My life is in the balance, and it shouldn't be.
It is unusual for someone who's accused of murder to do this interview or others.
I've seen the more information the public has, the more they understand what we already know. Good to see you.
And she might be right about that. She might be right about that. She says, I have nothing to hide. You know what I think is funny? The guy right here who's opening the door for her is totally like concealing his face. And like, I hope she finds a different hotel, because now that the hotel has been doxxed, I just would suggest that maybe she finds another hotel. Let's go.
The more they understand what we already know. Good to see you.
We first met Karen Reed at a hotel in the Seaport. She's logged 150 nights here since her legal fight began. It's the command center for her defense, and she is one of the commanders.
When we get new information, we just divide and conquer, and we can break it down really fast.
On the road, we drove by the financial services firm where she worked for 15 years before her arrest.
Little did I know, I'd reconnect with someone I had dated nearly 20 years earlier, and then he would be tragically killed, murdered, and I've been framed for it.
We appreciate you guys coming here. Reed's LA-based lawyer, Alan Jackson, joined her 3 years to the date of John O'Keefe's death. How much do you think about him?
Okay. So that indicates to me that 3 years to the date of his death was January 29th of 2025. That's when this interview was done. It is only, so this is a very, very recent interview. Very recent. She has spent 150 nights at that hotel since her first trial started. That's wild. I'm sure they're giving her some sort of a discounted rate.
To the date of John O'Keefe's death. How much do you think about him?
I think about him in terms of his final days, his final weeks. I mean, we have his cell phone, which a cell phone to anyone is like a diary. The time that I spent with John, 2 years, it's now been 3 since he's gone. And I have very mixed feelings, you know, when I look back on John, because I see a lot of poor decisions that were all precursors to his death.
Poor decisions by whom?
By both of us.
Okay, poor decisions. Poor decisions. I think we can all agree on the poor decisions. And she's going to say the alcohol, the drinking, the people we were hanging around with. A lot of people are going to think, you know, her comments are insensitive and she's not thinking about John. And she's thinking about John every single day when she's wondering why she's on trial for murder when her car did not hit John O'Keefe.
Just drinking, being around the wrong people is chief among them.
Reed admits drinking in the hours before O'Keefe was found unresponsive outside 34 Fairview Road in Canton.
She just repeated the phrase over and over again, I hit him, I hit him.
Multiple first.
Remember that guy? Remember that guy? Was that Nuttall or Flamati, that guy? That was the guy who knew Kerry Roberts, who like lived in the same neighborhood with Kerry Roberts. And that was the first time he ever said that too, because it wasn't in any of his reports. Hold on, let's look at him again.
Fairview Road in Canton.
She just repeated the phrase over and over again, I hit him, I hit him.
Yeah, he never said that before until he was on the stand, right? That was Flamati. Wasn't he the one that like knew Kerry Roberts and they lived in the same neighborhood? They went to the same parties and stuff, and he had a lot to say, and he never had said any of it before. Right, the housewife of Canton. Flamati. Yes. Did you laugh, Melanie? Something funny, Miss Little? Thank you, Carrie. Thank you, Carrie.
Multiple first responders testified that Reed initially said herself she hit O'Keefe with her SUV. Reed says she only questioned if she could have hit him.
Yeah, I went through every possibility. He was near the road and he was dying. And I didn't think he was purposely put in that place. It did not cross my mind for several days that they did this to John.
Okay. Did not cross my mind for several days. And again, Put yourself in her shoes. This is where you drop the guy off. The next morning you find his body on the lawn. What's the first thing that you're going to think about? Are you going to think that someone else did it? Or are you going to think that, I don't know, could I have hit him? Did I hit him? She admits to drinking. She did, because I think in another interview, another TV interview, she said that she had 4 drinks. Didn't cross my mind that he was purposely put there.
I didn't think he was purposely put in that place. It did not cross my mind for several days that they did this to John, that John was treated like a piece of garbage.
When Reed says they, she is referring to people who were gathered inside 34 Fairview. If John was beaten up and attacked in that house, who did it? We don't know.
We don't know.
We don't know.
All right. I don't look at Twitter. I'm not on Twitter, but I'm going to rewind that because I'm sure a lot of people are probably out there screaming, oh, look at the way they looked at each other. Oh, they're in love. Ooh. Whatever other nonsense they're trying to do by they're putting their doctored pictures and video of Karen and Alan Jackson. And by the way, it's often per se defamation when you accuse people of adultery. So I can't wait for those claims to happen. But that's what they're doing. In case you don't know, out on the cesspool of Twitter, is they've been doctoring videos and photographs to make it look like there's some sort of relationship between Karen and Alan. And I can tell you right now, could be per se defamation in many jurisdictions. So take a look at this exchange again. I'm going to turn off the closed captions for a second so you can see it better.
Act in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know.
Right. We don't know. Remember how she said they're going to retool their defense this time? They're going to retool it. Maybe, even though somebody called David Yannetti within the days following this incident and said, I have information. John was beat up in the house. Here's what happened. Here's who did it. His name was Steve Scanlon. He has since disappeared into the wind. We also know, because we saw the body cam footage, that when Karen Reed was arrested for the second time in June of 2022, when they upgraded her charges to murder, the body cam footage of, I think it was Buchanan, right, who was in the barracks, wherever she was brought. And, you know, they didn't call David Yannetti and say, you know, can you bring your client in as a courtesy? They knew she was represented, but they went and they arrested her and they cuffed her and they brought her in. She says on the body cam video, we're all in on the same joke, right? My taillight was cracked. John was pulverized. She names 2 of the people that were in the house as the people who beat him up and perhaps, maybe, murdered him. And that was way before she ever hired Alan Jackson, for the record, way before. So this narrative, this theory of the case was out there within days of her arrest the first time in February. Maybe it wasn't out there, but it was known to the defense. This is not something that magically appeared when Alan Jackson came on scene. A lot of people want to gaslight you into believing that we're all in on the same joke, right? That's right. So let's take that back again. Perhaps the retooling of this defense is going to be, we don't know who did it, because they did point fingers in the last trial. They did point fingers, Brian Albert and Colin Albert. And the O'Keefe family invited Brian Albert and Colin Albert to sit in court during the closings directly across from the jury, to stare the jury down during Alan Jackson's closing argument when he was pointing the finger at them, which was wild to me. Maybe they're going to say this time, like they just said, we don't know who did it. But John O'Keefe was not hit by a car. And if you have any doubt about how John O'Keefe's death happened, that is reasonable doubt. If John O'Keefe was not hit by a car, that's it. You're done. We go home. It is really that simple. I've been screaming this since the beginning. It is really that simple. The injuries to John O'Keefe's body do not line up with a pedestrian versus car motor vehicle accident. They just don't. They just don't. It's really that simple. And that's what got me interested in this case to begin with, in addition to the fact that it happened in Norfolk County. Let's take that back because they're giving us a glimpse into what their new trial strategy or their retooled trial strategy is going to be. We don't know who did it, but it is not a result of Karen hitting John with her car. That we can tell you.
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
What is the one?
And they don't need to prove it. They don't need to prove anything. All they need to do is raise reasonable doubt. The burden of proof is on the Commonwealth to prove beyond a reasonable doubt that this murder of John O'Keefe happened by Karen Read backing into him with her car and leaving him to die in the cold. The defense needs to prove nothing.
One thing in this case you believe proves your innocence.
John's body, no bruise, 6,000-pound full-size SUV, not a bruise on his body, not a fracture.
But again, she doesn't have to prove anything.
Below his head.
If you were framed, who's calling the shots?
I don't know the interconnections, the interpersonal relationships among these people. I have a strong personal opinion that what has motivated this persecution of me is power.
I'm declaring a mistrial in this case.
Reed says her initial thought of going through a second trial was a gut punch, but now she sees it as more time to prepare. She's talking now. Will she talk then?
I'm not afraid of taking the stand, and I'm clearly not afraid of speaking, but they're playing hardball. So we'll weigh the pros and cons, and we'll make another second game time decision.
Who would you rather face? Is it Adam Lally, who we saw in the first trial, or is it Hank Brennan?
I don't care who I face. I have the truth. I have the best attorneys. Do your worst.
Do your worst. She says, do your worst. I don't care who I face. She may testify, she may not. Another game time decision, just like she said. Do your worst. I don't care who I face. I have the truth on my side. Take that back.
I don't care who I face. I have the truth. I have the best attorneys. Do your worst.
One of the possible outcomes here could be a conviction. That could be prison time. How much have you thought about that?
I think about it every day, about prison time. And
oh, come on, don't play your stupid music on here because that could be copyright stricken because of the dopey music. Better not. All right, you guys, if this is, I'll link these videos below because if I have to trim them out, you'll know why.
doesn't frighten me the way it did 3 years ago.
Right.
Reed sold her Mansfield home in November to help pay her estimated $5 million in legal fees. She lives with her parents, who are a part of an inner circle that numbers about 10.
Only 10 people in her inner circle. Keep your circle small, people. Keep your circle small. Friendly reminder to keep your circle small.
Supporters have donated $750,000 to her defense fund. And she says people routinely pick up her meals.
I don't know the last time I've done anything but tip a waiter.
See? People are all, they're all out there. Oh, she goes on all these expensive meals and she's drinking martinis and blah, blah. Restaurant owners are feeding her for free. That shows you how much the general public feels that she is being railroaded and what's happening to her is unfair and they are outraged. There you go. She doesn't pay for expensive meals. She's comped.
And that generosity, that's all helping fuel this. It helps me spiritually and it helps me financially.
She's well aware not everyone has her back. John O'Keefe's family is convinced she's a killer and have filed a wrongful death lawsuit against her. Do you feel the presence of the O'Keefe family behind you in court?
I honestly, I almost look through them. Paul sitting there doesn't impact me, it doesn't bother me. That's John's brother. They've attempted to send me messages, and as soon as I see the name comes up, I just delete it.
What? They've tried to send her messages? They're trying to reach out to her? What? Okay, I think in song lyrics, and the first thing that came into my mind when I watched this for the first time was, the Alanis Morissette song from Jagged Little Pill, Right Through You. Remember that song? I see right through you. Remember that? I put up an Instagram story earlier today when I was promoting this show, and that was the song that I put with it. And you got to play that song really, really, really loud, and you'll get it too. I see right through you. I see right through you. They are sitting on top of her because of the configuration of this mini courtroom. It is like a little teeny weeny courtroom. And John O'Keefe's family is sitting right next to her, staring at her throughout the entire trial. It's the weirdest layout that I've ever seen in a courtroom ever. They're also staring straight at the jury because the jury is directly across the courtroom from them. David Yannetti, to his credit, and I think everyone wants him as their honorary big brother, has been blocking Paul O'Keefe from staring down Karen Read during the trial to the best of his ability. Anytime he's sitting there, he tries to block her, to be the block between them. And now she reveals that they've been trying to reach out to her. There's a stay away order. She's not allowed to contact them. She's not allowed to be within a certain number of yards from them. And now she says they've been trying to contact her. Hang on. Because this playbook, this play seems very familiar to me. It seems very familiar because it reminds me of the Aidan Carney case and what he is being persecuted for. And how allegedly the O'Keefe family invited a woman to court to come and sit with them one day so that Aidan Carney could not come to court because she had a stay away order against him. Right? And how she tried to bait him over to her house, which we know because there are text messages between Special Prosecutor Ken Mello, Lieutenant Brian Tully of the Massachusetts State Police, Mafia masshole Kate Peter, and the defendant or the witness or the alleged witness, Lindsay Gattani. There are text messages among all four of them about trying to get Aidan over to that house to try and get him to violate conditions. And that's when he got sent to jail for 60 days. So this seems to be maybe part of the playbook around here. I don't know what the duck is going on in Norfolk County. Thank God. But listen to this.
It doesn't bother me. That's John's brother. Paul's sitting. I honestly, I almost look through them. Paul's sitting there. Doesn't impact me. It doesn't bother me. That's John's brother. They've attempted to send me messages, and as soon as I see the name comes up, I just delete it.
Online, Read is book.
They're sending her messages, like texting her on Facebook. Where? And she just deletes it. I'm sure she screenshotted every single one of them. Yep. Wow.
Bombarded by love and hate. Yes, she pays attention. This case has become your identity. Is that for the rest of your life? Or will one day you just want to put it all behind you?
I don't think I can, even if I wanted to. And I'm okay with that.
We asked the Norfolk DA's office if we could profile and interview Special Prosecutor Hank Brennan. That request was declined.
Denied.
I'm Ted Daniel for your local station, Boston 25 News.
Denied. Wow. Okay. Wow. All right. Let's go to the chat for a minute before we play part two. Hi, Julie. Thanks for tuning in from Australia. Would Beverly Canoni be the judge in the appellate court? No, the appellate court is a panel of, I think, 7 judges. We covered the oral argument hearing for the appeal. They still have not rendered their decision yet. So no, she's not part of the appellate court. Great question, but go back. I have a whole entire Karen Read post-trial playlist, and you will find it there. It's called the Appellate Court Argument Day, I think, something such as like that. Australia is watching. Inside Down, Twilight Zone, thanks again for another super sticker. Spoken TC, thanks for your 5. If you rob a bank and someone dies, the driver gets charged also. So why not all 3 charge for Officer John O'Keefe? All 3 Who? I'm not following. I'm not following your question. Sorry. My brain is mush. I need more iced coffee. And let's go back over here. So that was part one.
State Trooper Michael Proctor.
This is part two. I'm really mad that they put music on this because it means I might have to cut it out, which I don't want to do. Part two, this is another 6-minute segment. I don't know if you guys have all seen this, but if you haven't, we're watching it again. No, don't play your stupid
Well, as we have mentioned
music.
this morning, Massachusetts State Trooper Michael Proctor is expected back at State Police headquarters this morning to continue a disciplinary hearing that could lead to his termination.
Proctor was suspended in July for conduct revealed during the Karen Reed trial. This morning, we've been bringing you Ted Daniels' one-on-one interview with Karen Reed. She was more than willing to talk about Proctor and others.
What troubles me is how evil people are.
We covered a lot of ground with Karen Reed, including those who want her in prison. The Norfolk.
Yeah, this is the hostage video for those who are always like, what are you talking about? What's the hostage video? This is the hostage video. Yeah, I think a lot of people are shocked by the evil out there. Take that back a little second.
DA with Karen Reed.
How evil people are.
We covered a lot of ground with Karen Reed, including those who want her in prison. The Norfolk DA, state police working for the DA, and specifically Trooper Michael Proctor. The detective zeroed in on Reed within hours of John O'Keefe's death.
Yep.
Proctor has testified that's where the evidence, including Reed's cracked taillight, took him.
Yes, she's a babe. Weird Fall River accent, though.
During Reed's first trial, Proctor's personal feelings for Reed were exposed in his personal text messages. What was it like to be there in court and listen to all those texts?
Proctor was just letting the public know what I've known about Michael Proctor, who he really is. Nothing Michael Proctor texted and admitted out loud in court about me would ever offend me.
Your figures of speech include the following.
Good on her. She's got a tough, thick skin. Nothing that he ever said could offend me. Good for her. You know what? She is like the epitome of strength and grace under pressure. I know there's a lot of people out there who trash her for her facial expressions and, you know, her skirts being too short for court and her handbags are too expensive. And she's seen drinking a martini or there's a martini on the table in front of her. And, you know, her suits are too expensive and, you know, she gets her hair done too much. And, you know, she has a tailor, you know, how dare she have a tailor? It's wild, like the nonsense that is being spewed out there. But how many people would be able to deal with this? For the 3 years that this has been going on, constant barrage of hate and vitriol that is so much louder than the support. Not where you guys, as far as you guys are concerned, but it's wild. And like someone said, it is pure evil. And I don't think a lot of people could never, ever withstand this. Terrific.
She's a bitch.
Objection.
Is that right?
Yes.
You spent hours having him read those out loud. I'm sure that was done by design.
It was. Everything that we did in that cross-examination of Michael Proctor was done by design.
There was an effort to indict.
Yes, it was. Oh, yes, it was. And remember, because I remember this last night when we were going over some other stuff when we were doing our halftime show watching Trooper Paul. Proctor, and I remember this. Proctor was on the stand for direct, and maybe the cross started, and then there was a day off, like midweek, I think, and then Proctor went on the stand again. Same thing with Trooper Paul. His direct started on a Friday, and then his cross started on a Monday. Like they needed extra time. Not the defense. They're not supposed to be prepped while they're under oath and currently on the stand, but Tell me if I'm correct. I can't remember exactly the date that Proctor started testifying, but I do remember that there was like a day off in between and before the cross started. My memory may fail me, but everything was done by design when it came to Michael Proctor. Let me hear that again.
In that cross-examination of Michael Proctor was done by design.
There was an effort to indict Reed on new witness intimidation charges last March. It failed. Reed says even people around her were under scrutiny.
Our
Right.
drivers have been
So for those of you who don't know, last March of 2024, they convened another grand jury in Norfolk County trying to indict Karen Reed and Aiden Carney for conspiracy to commit witness intimidation against some of the witnesses in Karen's trial. And it had to do with a rolling rally that Aiden Carney, aka Turtle Boy, hosted, where he drove around past houses of certain witnesses and may or may not have said things on a bullhorn. I'm not really sure because I wasn't around at the time that this went on. They say, or Saul Wachtler said famously, who was the Chief Justice of the New York Appellate Court, the Court of Appeals is our highest court in New York, famously said, a good prosecutor can get a grand jury to indict a ham sandwich. Well, not in that case, because that grand jury failed to indict Karen and Aiden. And in my opinion, that attempt was made specifically to incarcerate Karen Reed because she's been out on bail since the beginning of this case. And had she violated those bail conditions, they would have been able to throw her in jail. Turn the screws a little more. Get her to take a deal. Not let this see the inside of a courtroom. That was in March of 2024, which was before the first trial started. That's exactly what they wanted to do. It failed. That ham sandwich was not indictable. So there's that. Okay, I see what you're saying. Spoken TC. If you rob a bank and someone dies, the driver gets charged also. So why not all three charged for OJO? Meaning Brian, Albert, Higgins, and Collins. Because none of them have been charged at all. At all. And if it turns out that there are people who covered up some sort of crime, they can all be indicted. And there can be many, many more people than just those three. But just so the record is clear, nobody else has been charged other than Karen Reed. So there's that. And nobody really knows what happened unless they were there and they were an eyewitness to what happened and could testify. Nobody knows what happened that I'm aware of. So that all remains to be seen. And it may turn out that nobody ever will be held responsible for the murder of John O'Keefe. And that is the biggest tragedy of all.
approached by the state police, had very close friends, had our driver
failed. Reed says even people around her were under scrutiny.
Our drivers have been approached by the state police, had very close friends, had their cell phone records subpoenaed.
What?
For an indictment that never happened.
Have you ever been?
What? Very close friends have had their cell phones, their records subpoenaed? Her drivers have been questioned, aka threatened by the Massachusetts State Police. We know that at some point they obtained, I think, Aiden Carney's financial records, his banking records. They were trying to say that Nathan Reed worked for Lexus and they gave Aiden Carney a Lexus. And I think at one point we found out that they did somehow subpoena like Mr. Reed's, her father's banking records too. Am I remembering this correctly? And maybe even her brother's financial records. Like, it's insane. Like the lengths that they have gone to try and shut her up is mind-numbing. Talk about abuse of power. Yeah, among very many other things. Julia, right? I mean, it's wild. The deeper this goes, the crazier it gets, says Jen Logan. Right. At the beginning of this interview, she said she went to New Hampshire for 2 months after the first trial, right? Yes, that's what she said. You're right. Yeah, I would love to see what judges signed all these warrants to, right, Son? They were trying to collect, they were on a fishing expedition for more evidence to try and get Karen and Aiden on witness intimidation charges. Didn't work. And it's insane.
Been follow?
I don't know.
I gotta take that back because I missed the beginning.
For an indictment that never happened.
Have you ever been follow?
I don't know. My eyes are akimbo all the time. I look at law enforcement differently, more warily.
How do you know you're being tracked?
Well, she doesn't know if she's being followed, but we've seen evidence of, or Aiden Carney has uncovered evidence of certain people tracking her to that hotel. That they may not have been law enforcement, but there are definitely people out there who are following her around. She got her head on a swivel at all times. Could you imagine? Not only is she dealing with this wrongful persecution, but she's got to worry that she's being stalked, followed. I hope she has a bodyguard. I'm outraged. I have a renewed outrage right now.
Enforcement differently, more warily.
How do you know you're being tracked?
I know from affidavits from the state police at the Norfolk DA's office. Yeah. They knew what flight I was on. They knew when I landed. They knew when I came back. And it's disturbing. It's invasive, and it's desperate.
It is desperate.
Ted Daniel joining us now.
Not wrong. It is absolutely 100% desperate. They are trying to scare her. They are trying to scare her. They are trying to intimidate her. They are trying to scare her. And she's the toughest chick I know. I'm just saying. That is insane. They're tailing her. Wow.
Fascinating interview, Ted. There, she just called the state police desperate. Others may have used that word to apply to her, and seeing she didn't get an acquittal the first time around. But why do you think it is she agreed to do this interview?
She comes across as very smart and analytical, that every move that they're making, she's a part of, and it's calculated. I think she says to me she has nothing to hide and wants to get her message out. I would expect that, they went over the pros and the cons of this with a trial fast approaching. And in the end, they thought it was something that they wanted to do. It's not the first time that she's gone on in a segment like this. She did a couple national interviews. And I think that this was something that, I reached out to her team and heard back within a couple of days.
I actually have two questions for you. What is she like off camera too? Same way?
Yeah, pretty much the same. You get the feeling, she's always on the phone or she's always making plans. She's, when we met her, the day that we met her, she was going to meet with her lawyer, Alan Jackson, she said, because she had a private investigator hunting down a new lead, and they were going to analyze and go over what information that was provided to them. So, yeah.
She is laser focused, and she is so involved in her own defense. Laser focused. Amon, thank you for looking this up. You guys are so collaborative. I am so happy to have this information. Trooper Proctor was day 21. That was Thursday, June 6th. Friday must have been a day off because his second day of testimony was June 10th, which was a Monday. That was day 22 of trial. And then he testified on a third day, which was June 12th, which must have been a Wednesday. So a Thursday, and then a Monday, and then a Wednesday. Coincidental? I don't think so. I remember when the trial was ongoing and the judge had announced a number of days off that they were not going to be on trial. I believe it was a strategy of the Commonwealth to put certain witnesses on the day before a day off. For whatever reason, maybe the witness would need a chance to regroup. think about their testimony.
Yeah, I mean, she's very
Yeah.
cordial, very nice person, you know, but when you look at all in this totality here, you know, these are some really serious charges against her, and she's got a tough road.
Yeah.
So you reached out to the DA's office as well.
Yeah, we wanted to give equal time to you know, the DA's side of this. So it's the new prosecutor. Adam Lally did the first trial, and now Hank Brennan was appointed a special prosecutor. He's you know, long known defense lawyer. You know, I used to
the Whitey Bulger case.
Yeah, and I used to speak to Hank about, you know, other stories. So we made a request. We said, hey, we'd like to profile Hank and give him sort of, you know, an on-camera interview, and they declined that request. And I get it. There are some stipulations that the DA and the prosecutor has to follow in terms of out-of-court discussion. I did say, hey, I realize in my email, I said, I realize there may be some things that have to be left off the table. We were fine with that with them, but unfortunately it didn't happen.
You had talked about this in the piece that aired last night.
Wait, is he talking about interviewing the Commonwealth? Yeah, because they said no. Hey, hold on.
Court discussion. I did say, hey, I realize in my email, I said, I realize there may be some things that have to be left off the table. We were fine with that with them, but unfortunately it didn't happen.
You had talked about this in the piece that aired last night, and she has talked to, as you mentioned, to you and to other outlets. The question is, will she take the stand now in the second trial? And she mentioned, well, that'll be a game time decision. What's your gut telling you on that?
I think she probably won't. I mean, as rare as it is for her to do all these interviews with us, I think would be more rare for her to take the stand. But one of the things that the new special prosecutor is trying to do is take all the statements that she's made and find contradictions. Before this story even aired, we got a court order at this station saying the DA's office wants all the raw interview. They want everything. And
Wait, stop, Ted. I don't think it was a court order. I think it was a motion. You got served with a copy of the motion because Hank Brennan sent the Massachusetts State Police with a copy of the motion to your record keeper. I don't think there's an order yet, just so the record is clear, Ted. But I'm going to check the docket. But he's right. Before it even aired, Hank Brennan had the Massachusetts State Police serve as his process server to go on over to the record keeper of NBC. No, this is not NBC. This is Boston 25 News. Serve them with a copy of the motion. We want your outtakes.
My notes. So the DA's office has been doing that to everyone that she's spoken with, because they want to say, hey, there's this inconsistency there, or she said this during this interview, said something different during another interview. So it was surprising, though, that we got it 14 hours after the promo aired and the story hadn't even gone on TV yet.
That's right.
Yeah. It's, you know, expected almost too, but it's something that so many eyes are going to be watching. I mean, you did an incredible piece on that story as well. And yeah, I'm looking forward to see what happens.
There will be
Yeah, that's crazy, right? He wanted to give them equal time. He wanted to give the Commonwealth equal time. They didn't want it. They didn't want it. The process is the punishment. But Michael Marcy thought it was okay to go out and do that hostage video and just release that to the general public. But, you know, when they're asked by a reporter if they want to come and give their side or say anything, no, we don't want to do that. Only when Michael Marcy goes out and releases a hostage video. This has to stop. Colin Albert was never in the house. These people are being, picked on, and they had nothing to do with this. Michael Proctor never went to the scene at 34 Fairview. Karen Reed is guilty. I don't know if he said Karen Reed is guilty, but he might as well have, because that's exactly what he was intimating, that her theory was ridiculous, that anybody else did this, right? We've watched that hostage video so many times. We can find it if you guys want to watch it again. Happy to watch it again. So that is... Those are the two that I have. Is there a third? Because there's a 2-minute one. There's another 2-minute promo. But is there another 6-minute promo? Because I don't see it here. If anybody else has it and they want to email to me, I'll put up the email. It's fanbase@mlittleLaw.com. Oh, wait, hold on. Suze did it. Hold on. All 3 clips should be here. Okay, well, let's see. Let me just play this for myself for a second. Yeah, this is the 3rd clip. This is the same one that I'm about to play. That's only 2 minutes long. So hang on. I got it on YouTube. Let me put this up for you. It's too hard for me to pivot when, I actually do prepare for these shows. So hold on. All right, here we go. This is the 3rd part. Stop with your
More
stupid
now
music.
from Boston 25's one-on-one interview with Karen Reed. We've known about a federal probe tied to Reed's allegations of a police cover-up in this case for years.
Feds turned over thousands of pages of evidence to both sides before the first trial. And just last week, new U.S. Attorney for Massachusetts Leah Foley would not say where the investigation stands.
Here again is Ted Daniel with that layer to this case.
I picture every day that they're working on framing me.
It's no secret. Karen Reed believes she's being railroaded, and critical aspects of her defense have come gift-wrapped from the feds.
All accounts, he didn't do anything wrong. She's a whack job.
State Trooper Michael Proctor's personal text messages, butt dials, and discarded phones.
Did you pull the SIM card out of your phone, Mr. Higgins?
Independent scientists who testified that John O'Keefe's injuries were not from an SUV.
The theory of the case is a car accident. The federal materials included a report that said there wasn't a car accident. That's 95% of the case.
The feds devoted a lot of
Yeah, exactly.
time and resources investigating what happened here. We are now years removed from that, and there's been no action taken.
Well, I don't know that there's been no action taken.
But no indictments.
No indictments.
25 investigators learned the Norfolk DA's office has communicated with the U.S. Attorney's Office about this case since Reed's mistrial in July. The DA's office denied our public records requests for any emails or letters, citing in part a federal protective order. Do you expect that having a new head of the U.S. Attorney's Office in Boston will change anything?
But I can say that I was very, very happy with what they did and what they disclosed, trying to get the truth out previously, and I hope Ms. Foley does the same thing. I'm looking forward to her continuing the investigation. I hope she does.
As for Michael Proctor, he's scheduled to have a disciplinary hearing tomorrow to determine his future with state police. Karen Reed has a lot to say about Proctor. Ted will join the Boston 25 Morning News team tomorrow at 7:15 with that portion of his interview.
Okay, you're saying that it's live right now on Boston 25? Hang on. Hold on. Where's the live feed on here? Hold on a second. Too many ads on here, too many pop-ups. Hello. Happening now. No, the one that they're showing here is from 7 this morning. Hold on. We just watched part 3. That was part 3, right? Okay. All right. Everyone's confusing me. Thank you, John Monagle. All right. All right. Here's what we're going to do now. Now, for those of you who have never seen this, and even for those of you who have, you will probably be outraged anew. You'll be outraged anew when we watch again together. It's only 5 minutes long. We watch Michael Marzi's hostage video from August of 2023. It's 2023, right? August 25th of 2023. Michael Marcy, the district attorney of Norfolk County, came out in an obvious attempt, in my opinion, to taint the jury pool. Released this video. It's not a press conference. There was no media in the room. I call it a hostage video because it seems to me, think about this while we're watching this, whether someone is off camera holding a firearm at his head, forcing him to read this written statement. Who drafted it? Who's off camera holding the weapon? We have books behind him that do not appear to be in any sort of order. If you look here, there's 425, 423, 412, 414, 415, 40. I mean, obviously, there's Westlaw, LexisNexis. We don't need books anymore, but, you know, let's do it for the look. For the look. Federal reporters all out of order. We're going to watch it. God save the Commonwealth. David Yannetti said in open court one day, I have never, this is unprecedented, never seen anything like this in my 30-year career. Neither have I in my 30-year career. That he has a friend who I think is a law school professor who is showing this to his law students as something you should never do if you're a district attorney. Here it is. If you've never seen this before, enjoy. Michael Marcy released this to all media, August 2023.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Read is absolutely baseless. It should be an outrage to any decent person, and it needs to stop.
It needs to stop. It should be an outrage to any decent person. What is an outrage to any decent person is this wrongful persecution of a woman who did not hit a Boston police officer with her car. And you are now you have upcharged her to murder. I'm sorry. I'm going to start that again. His first statement of its kind since he's been Norfolk District Attorney. Why? Why is he doing this? Why? Think about that.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Read is absolutely baseless. It should be an outrage to any decent person, and it needs to stop.
Any decent person.
Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died.
Really? Is that what the evidence showed? And that's what you were out there telling the Norfolk County jury pool that the evidence shows that John O'Keefe never went in the house? Are you kidding me? Are you kidding me? I have never seen a sitting district attorney get out there. Now, this is outraging me, I knew. And tell the public that there's no evidence that this happened, that her theory is BS. Why is he testifying? This is his hostage video. I call it a hostage video. No evidence that John O'Keefe ever went into the house.
Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that his phone did not enter that home.
Wow. Wow. Location data from his phone shows that his phone never entered the home, despite the testimony that there was a margin of error. And this is the district attorney. Okay. In August of 2023. Trial started, I don't remember exactly when. April 2024? What the duck? He's telling us now that the phone was found on the lawn underneath his body. We didn't find out until trial that Carrie Roberts is the one who allegedly picked it up from underneath his body. Yeah, technically you can say that because they never investigated whether he went into the home or not. Wow. He entered the home. His Apple Health data shows it. And it shows him going up and down 3 flights of stairs. You're correct, Melissa. You're being gaslit.
"11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one.
Wow, but you know what's so funny is that at trial, Brian Higgins, who it's rumored took a federal proffer, said that he did see an unknown man enter the house that he didn't recognize, right? A tall man with dark hair. It's wild.
Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all.
Second time. That's the second time. He said the phone evidence shows John O'Keefe never entered the home at all. Now he's in defense of Colin Albert.
Witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert.
I lost count. How many times has he said now John O'Keefe did not enter the home? 4 times, 5 times, 6 times?
The young man being vilified was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder.
This is a false narrative. In other words, Karen Reed's theory of the case is false. It's BS. This is a false narrative. Karen Reed is guilty. You might as well just say that. Yep. And Julie Nagel says she saw a blob on the front lawn near the flagpole, though, right? And now they're trying to say his body was found along the road. Ipsy Dixit, right? Because he says so. Hold on, wait.
Vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder.
Colin Albert didn't commit murder. Who scripted this?
Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly.
Wow, Jennifer McCabe, Matt McCabe, and Brian Albert. These people were not part of a conspiracy.
They did not commit murder or any crime that night. They have.
Take your pick. Who drafted this? Matt McCabe, Jennifer McCabe, Brian Albert, or Colin Albert, or someone on their behalf? Because that is exactly what this man is doing. This elected official, this man who is paid by the taxpayers of Norfolk County, has just told you Colin Albert, Jennifer McCabe, Matthew McCabe, and Brian Albert, none of them committed any conspiracy or were involved in any conspiracy, and none of them committed murder. This is a false narrative. He's reading from a script. He's absolutely reading from a script. Look, he's looking down. They could have at least had a teleprompter for him or some cue cards, but no. That's why I call it the hostage video.
Have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime.
They have not engaged in any cover-up. They've been very forthcoming, very helpful. They're not suspects in any crime. This is wild. Wild.
They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight.
Yeah, isn't that so weird? I mean, you guys follow a lot of true crime. Many of you are medical professionals, legal professionals. You ever see a doctor write in an autopsy report, or a medical examiner write in an autopsy report what didn't cause the death? You know, like he didn't fall off a cliff. These injuries were not from a fire. These injuries did not occur from drowning. No, but this medical examiner put in her report, these injuries do not seem to be consistent with a fight. And much to the dismay of Michael Proctor and Yuri Buchanek, put her manner of death on John O'Keefe's death certificate as undetermined, despite their best efforts to get her to change it to homicide. And that is when, in those text messages that the feds uncovered, the group messages with Proctor and some of his other troopers, that is when DeChico said, "Rookie move. You should have let me and Jeff do it." Jeff being Trooper Jeff Katowski, who coincidentally, or not so coincidentally, was in the room during the autopsy of Penny McGee's ex-husband, Andrew Savitz. That medical examiner, who is not the same medical examiner here, but the other weird coincidence is that Andrew Savitz died 2 years to the day earlier than John O'Keefe. It was January 29th of 2020. That medical examiner changed her manner of death from undetermined to homicide within 3 months. And that decedent, Andrew Savitz, died of a heart attack and had a 90% occlusion of his carotid artery, in addition to diabetes, a prior stroke, 2 major car accidents, had a verbal altercation with his ex-wife. Maybe she shoved him, but he dropped dead of a heart attack. That medical examiner changed her manner of death to homicide. Irene Scortibello, in this case, did not. And to this day, Officer John O'Keefe's death has not been ruled a homicide by any medical examiner. So there's that. Not a result of a fight. So
A further fact, John helpless chief medical examiner.
She also did not opine that they were a result of a car accident.
The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime?
Really? You're saying that Karen Reed deserves the presumption of innocence when you're saying that her theory of the case is complete and utter trash and false? Hold on a second. You are not giving her the presumption of innocence. So I can't believe you're talking about her. Hold on.
Not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime before?
Again, he's saying these people committed no crime.
Reported less by members of the community. They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence.
Wait, what?
The internet has no.
What are you doing? You're trying this case on the internet. There's not a reporter in the room asking you a question. That statement belies exactly what you're doing by releasing this hostage video to the media. Listen.
Who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts.
Neither do you.
Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt.
This is a desperate attempt for you to taint the jury pool, counselor. a desperate attempt for you to taint the jury pool and obviously to defend some people that you may have a personal relationship with, because never in the history of ever has any district attorney come out and done such a thing. It's unprecedented for a reason. This is wild. He just said that her entire theory of the case was a conspiracy theory. Wow. To reassign guilt. Yep.
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident.
Well, there's conflicting reports about that now, too. Christina is like, who is this guy? Who is this guy? This is Michael Marcy, the district attorney of Norfolk County, Massachusetts, who released this statement to the media while someone may or may not be holding a gun to his head off camera in August of 2023, way before the first Karen Read trial. This is what we talk about when we're talking about the hostage video. Michael Proctor being at 34 Fairview on the date of the incident is up for debate because some reports say that he was. Reefer Madman. Reefer Madman says he goes down if they go down. Yep. Wow.
Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road.
And that is a declarative statement. Trooper Proctor did not plant evidence at 34 Fairview Road. He's scared of something. He's scared of something. This is so blatant.
In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict.
Well, we know that to be a lie because the feds found out. And then Michael Proctor was forced to testify about it at trial. So he actually did. He did. He absolutely did have a personal relationship with people involved in the investigation, including Julie Albert, who he asked to babysit his children. He was going to ask Julie Albert, Colin's mom, to babysit for his kids like 10 days before John O'Keefe's murder. There are text messages. There is a text message from Colin Albert's mother to Michael Proctor's sister the day of Karen Read's arraignment, February 2nd, 2022, that says, "Tell your brother I want to get him a thank you gift when this is all over." Yeah, there's that. So he did have close personal ties. They were found out and he was forced to admit them on the stand in front of a worldwide audience. Let's take it back a little bit. For those of you just joining, welcome to Michael Marcy's hostage statement from August of 2023. This was right after, I think it was the Commonwealth who moved for a gag order. It was denied. There was an interview of Karen Read that may have aired the night before this. Don't hold me to the dates, but in close proximity. And therefore, Michael Marcy felt the need, or someone told him that he had to go on camera and read this statement and release it to the media. There was a motion to recuse him after this. That too was denied. He says, Michael Proctor did not plant evidence 34 Fairview Road. In addition to having no opportunity to do so, he would have no reason. Listen.
To plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict.
Really?
And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie.
Well, that's so funny because today was hearing day number 2 of his disciplinary proceeding with the Massachusetts State Police, where they're going to decide whether or not he's going to be terminated. He's been suspended without pay for his activities in this case, specifically since the summer, right after the mistrial was declared on July 1st of 2024. And yeah, so there's that. This did not age well, did it? Proctor appeared in front of the trial board for the second day today, and we are now told that there will be at least a third, maybe a fourth day of hearings for Michael Proctor's perhaps termination with the Massachusetts State Police. Listen to that again.
And he had parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie.
A lie.
This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop.
What about Karen Reed's constitutional right to a fair trial that you were completely invading by releasing this exact statement? So are you talking about the fair trial of Michael Proctor? Because that's going on right now too. Yeah, it's an administrative proceeding in front of the Massachusetts State Police. But, you know, the fact that you got out there and defended him doesn't look so good for you now, does it? Since the internal affairs investigation is popping off as we speak and going to be continuing for, you know, another at least 1 or 2 days of hearings. So whose constitutional right to a fair trial are you trying to defend? Proctor's? Albert's? Higgins? Or Karen Reed?
Case is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now.
It needs to stop.
I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
It needs to stop. It's wrong. It needs to stop. Hold on, because I need to take that back a second, because remember,
Innocent people, these witnesses, is wrong. And
a lie unchecked becomes the truth. Didn't we just hear that the other day out of Brennan's mouth? A lie unchecked becomes the truth. This was tailored. Yeah, this was tailored. Yeah, the reason I didn't do this in front of any reporters is because I didn't want to have to answer any questions about why the duck am I giving this statement in the first place. This needs to stop. Listen. I had to narrowly tail that I'm releasing this quoted statement. You mean drafted? You mean scripted? Rather than holding a news conference, because I don't want to have to answer questions. Listen.
News conference because my remarks need to be so narrowly.
This needs to stop.
Stop now. I am releasing this quoted statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
Yeah, it needs to stop. So why are you doing this? How many of you have never seen that before in the chat? Put a number 1 in the chat if you're a live chatter. If you've never seen that before, put a number 1 in the chat. I'm just curious as to how many people have never, ever seen what I call the hostage video. Wow, there's a lot of people who have never seen that before. Wow, I felt like we overplayed it, that we have played it so many times. Wow, look at all of the people who have never seen it before. And for those of you who have never seen this before, who are putting a number 1 in the chat, are you horrified? Are you horrified? Michael Marcy has been your district attorney since 2010, and he has never been opposed. He's never had anybody run against him. Wow, just wow. Yeah. Right? You should play it every day. I'll link it below so you guys can go back and watch it again at your leisure. But yeah, people are like sick to their stomach, blown away, shocked. shocked? Let's do a poll. Every time I see it, I become more horrified. Erica Madden, thank you for the 20. You know how outrageous this is when many of us have heard and seen it so many times, and it's still cringeworthy and not ethical. I mean, that's being kind, Erica. Thank you for being kind. We try and be kind here. But when it comes to something like that, how can you be? Talking about unbiased and talking about Michael Proctor is not guilty of anything. I mean, those are some pretty strong words, right? Pretty strong words. It gets worse every time. Mariko, true, says play it again in November 2026. Marcy's up for re-election. All the deities help us if he gets re-elected. There are some people who are stepping up to run against him. So there's that. Thank you, Lori Lake, for tuning in from Canada, for your super chat. Thank you for stating the obvious for the oblivious. Thank you. Thank you for watching always, Lori, and for your kind and generous support. Where can we watch the whole interview? It's in pieces. It's in bits and pieces. A lot of people outside the country are not able to access Boston25.com. There has not been, as far as I know, it released in its entirety in one piece yet. So bits and pieces are what we watch. Thanks, Terry, for that. If anybody knows any differently, certainly put it in the chat. Karen became a new member. Captain Trips says, never trust a cop, any cop. All right, I'm going to have to disagree with you there because I do back the blue 100%, but I think that there are bad cops and there are good cops. And I also am going to say that always, never, I'll say never speak to the police without an attorney. Just don't, especially if you're innocent, Melissa, the trial interruptions were very strategic, courtesy of the judge. I don't know that it was courtesy of the judge. There were certain days when it was announced that there was not going to be court because she had other cases to cover or whatever. I am saying it could have been strategic on the part of the Commonwealth. Oh, well, we know there's going to be a day off on Thursday, so let's start Proctor's testimony on a Wednesday. Then he'll come back on the Friday, and then it'll be the weekend, and he'll come back on the Monday. That's what I'm saying. Janine, are there any travel restrictions with her trial restriction? I'm sure that she had to surrender her passport, but as far as traveling within the United States, I don't think so. Dove's House, why do you think the defense hasn't filed a similar motion as the one today for the video, but for the key cycle source data forensics, they're working on them. They just filed an extension on Friday to extend their time to file evidentiary motions. We're waiting for that, see if it's going to be granted. You can expect a lot more motions to come. They've been working on all of this BS. All of the motions the Commonwealth has been filing with regard to Daubert hearings and other things, and Richard Green's testimony. And remember also that the time for the defense to turn over their evidence does not run until the Commonwealth files its certificate of compliance. They didn't do that until last Thursday. And today is only Monday, believe it or not. It is only Monday. So that's why now they say we've turned over everything. Now is the time for the motions to start flying, and we're here for it. Chivi says the only way to handle Marcy is acted out by Will. Yeah, he's got a great impression. Will does have a great impression of Marcy. John is holding Karen's hand, guiding her, says Kimmy. Thank you, Kimmy, for tuning in from Canada. On top, in with the super sticker. Thank you so much. Stephanie says, outrage is our word, sir, not yours. Thank you, Stephanie, for your super chat. Mama Suze, the head of the grand jury is the daughter of a Boston police officer. 6 of her uncles are Boston PD as well. This was so rigged. Thank you for your opinion, Suze. And I heard something like that reported. It's weird, coincidental, crazy. And just another one of a long line of coincidences, but I have not been able to confirm or deny that. So I just don't know, but that is what is being reported out there. Greg says either he is scared Karen will find out his dirt or someone, cough, Jen, cough, has already said dirt. Either way, he's doing this because he's scared. You're talking about the statement that we just watched. Super sticker. Thank you for being on top. Thank you for being on top of another super sticker. Craftastical. Why would he put this out saying all that didn't happen if there wasn't some truth? Thou dost protest one's innocence. Thou doth protest too much. You think? And a lie unchecked becomes the truth. Crazy. Sue's again, another super chat says, knowing what we know now, it's more offensive than it was in August of 2023. He knew this was all lies. Cheryl F., thank you for gifting 5 memberships. That is so very kind and generous to you, and welcome, welcome to the 5 new members. It was so kindly gifted by Cheryl F. Pierce says if you just flip everything Morrissey said around, you basically have the defense's theory. Yes, although we've learned from the new interview that Karen did with Ted Daniel that perhaps the theory is now going to change. We don't know who did it. We're not going to point the finger at anyone specific, but it wasn't Karen Reed hitting John O'Keefe with her car. And that might be a better way to go with the jury, because we saw what the jury did in the first case. And we still sitting here waiting to hear from the appellate court on whether or not that jury is going to be called back to determine whether or not they did actually acquit on counts 1 and 3, but they were just never asked about it. Thank you very much to Mr. Goodman, Brian Goodman of the Goodmans for his Venmo. Mr. G says hello. Get a couple martinis. He says, love Mr. G. Thank you so much for your Venmo. You guys are awesome. They try and outdo each other with super chats, and it's so cute. Justin Green also, thank you for your Venmo. Full speed ahead for the free Karen Reed defense team. Preach, bro. Preach. Let us see if we have any more questions, thoughts, questions, comments, concerns before we wrap this almost 3-hour stream today, because you never know what's going to happen. You just never know what's going to happen. Adam Handful says, mark my words, they're going down. Time is of the essence. We're continuing the playlist. Time is of the essence. We'll see what happens, but now we've got Right Through You added to the playlist, the amazing Alanis Morissette song. Follow me on Instagram if you don't already. My Instagram is in the show notes below, and you can do that there. And I usually post my shows on my Instagram story, and then I give you a link so that you can hit the link and then go hit the reminder bell so you don't miss a thing, because like today, I often just go live within 30 minutes. And I try and give 30 minutes at least, because if you have all notifications set, you will get a notification with 30 minutes notice. But you have to have all notifications set, and you also have to have your iPhone or your phone set to allow YouTube notifications on your phone. Then you won't miss a thing. But of course, as always, replay members are loved just as much as live viewers. Replay viewers are loved just as much as live viewers. So thank you so much to my moderators who always keep it classy in here every single time. And this is a really difficult case for a creator to cover. It would be impossible without the help of my amazing moderators who are so on top of it all the time. The name of the playlist is the Karen Reed Trial Playlist. I can link that below too. It's on Spotify. We did that for the first trial. The chat does have common sense, right? I'm just going to check the docket one more time. I got to extend my time here just to see if there's anything else filed, which I'm sure would be in my inbox right now. I don't see anything in my inbox right now. So I'm just going to check it real fast. The 18th is a hold date for something. I'm not sure what. We don't know. Maybe it'll be for this motion that we just listened to today. They are holding the 18th for a hearing date. And then March 4th and 5th are motion hearing dates. Final pretrial conference on March 7th. There's another hold date of March 18th for what also says final trial conference. And then also the 19th of March is held. And then the trial is alleged perhaps to be starting on April 1st. Let me just check and see if anything else was filed real quick. Interesting to see the Commonwealth's response to this. Like, really? You don't want to give them the metadata? Well, there's an updated scheduling order. That is docket number 485. Docket number 485 was the last thing to hit the docket. So I'm not sure if the judge did give them more time to file their motions, because there is an updated scheduling order that hit the docket today at some point. It's number 485. So it hit the docket after the motion and affidavit hit the docket. That'll be something for us to cover tomorrow. Thank you, Stephanie, for becoming a new member. Appreciate you always. I know that you've always been a member, but you probably just re-upped and add a handful. Says always educational. Thank you. No, thank you. No, thank you. Thank you, everyone. I love you with all of my heart. If I don't see you soon, I'm going to die. Stay cool, stay kind, stay classy. You can do it. I know you can do it. The other people out there, not so classy. You guys can do it. It's not hard, really. It's not hard. Your life will thank you. You'll be so much happier. Peace. Good night, my friends. Stay safe out there. Head on a swivel and free Karen Read.